Item 2.
I made certain observation, and I've said that even for interim Jima up to the cattle, the prime consideration is the well-being of the cattle, and the observations are on the basis of the various judgment of different High Court and Supreme Court. And insofar as this case is concerned, I have set aside the impugn order and remanded back to the court below for reconsideration on the basis of the observation made. Yes.
I beg pardon to make a mention, my lord. It's a very unfortunate case, my lord. A doctor is convicted on for 2 years in a vigilance case, my lord. My lord, after this judgment of conviction is passed, my lord, he was terminated from service in view of this conviction order, my lord. Now he has expired in the meantime. His wife is now, my lord, facing very difficult to survive, my lord, because 2 minor children are there, my lord. My lord, she has been allowed to represent, prosecute the case, my lord. And one application is also filed for stay of conviction. Your lordship, if your lordship takes out, because they're in a very distressed condition, my lord.
You want that the application should be heard or main matter?
Main matter can be disposed of within 5 minutes, my lord. It will take just 5 minutes because there is absolutely no matter.
This is a revision.
No, it is an appeal, my lord.
Appeal.
Appeal.
It can't be disposed of within.
No, my lord, because there is absolutely no material that he has received any money, my lord. None of the witness has said, my lord. At best, it could have been.
Which year appeal is this?
My lord?
Which year appeal is this?
2018, my lord.
18.
8. Your lordship is taking up after 2015.
She coaching their conviction cannot be stayed in view of that.
No, I'm not going to say conviction.
So, but
That's for
appeal
sure.
hearing, final hearing is
If the appeal
concerned.
can be heard of, we will.
Appeal hearing, छुट्टी परे आसु
छुट्टी परे आसु
appeal hearing गुड़ाए केस सब
The survival question is ପିଲାମାନଙ୍କୁ ପାଠ ପଢି ପାରୁନି
ସେଟା ତ ହବ ସେଟା ତ
2018 onwards, the
consequential.
same thing happened. Now, why the survival is a problem?
2 ବର୍ଷ conviction ସରିଯିବ ସାଙ୍ଗେ ସାଙ୍ଗେ ସରିଯିବ ଭାଇ
ସେମିତି ତ ହବ ନା
otherwise
ଯେ
I would have mentioned my lord had there my lord
Give the particulars to him because he is also
yes my lord criminal
ready,
appeal
because the old matters he has to cut hold of his brief also.
I am supplying my lord criminal appeal number 289 of 2018.
You supply your paper book, let it be in the second
Paper
week of May.
paper book ହେଇଛି କି ନାହିଁ that is that
paper book
paper book ହେଇନି କେମିତି କଣ
and
ଆगे paper book
Paper book
the
means
condition
your
of that
revision
lady is
your revision petition and whatever you have filed, 161 statement, so once evidence and all, whatever you have, you must be having the document.
more
You give the supply him.
first paper book तो your lordship में direct filing of paper books
What,
register your lordship में direct
paper
register
book nowadays your lordship knows me even live conviction order
least this matter we will regulate it first.
yes
Least it matter we will regulate. Least next week we will regulate it.
problem
First.
May I beg pardon, my lord.
My lord, this is a fresh criminal miscase, my lord, of the year 2023, my lord.
I beg pardon, my lord.
Yes.
Item 67 and 68, my lord.
on Belgium
First,
on Belgium
Yes,
matter
Belgium matter.
And another my lord, release of vehicle is filed since January, my lord. 801 of 224.
We'll give you Belgium because from tomorrow next Monday.
May I be permitted, my lords? I'm an executive engineer. Now, I am retired. This is the revision against charge. It is a 23 matter, but could not be heard because a wrong statement was made by the State Council that charge has been failed. It has become infructuous. Then a report was called for.
Matter of FIR?
No, it's a decade before, my lords. But
And
it's
you want
against
to
charge.
obtain a stay and it's going on.
No stay order is there. It's a fresh. It has never been heard. Now, there is no interim order. Because of the wrong statement, a report was called for from the trial court that no charge has been framed. Thereafter, Millers, for the last 6 months, it's not listed. We are taking time before the learned court. Now, as a last chance, he has fixed it to 18th. But I pray for Millers, subject to availability of time, let it be listed. If possible, your lordship may hear it or fix it a date for hearing.
Just take it up. We'll see.
I mean,
Only may be listed subject to convenience. Thereafter, your lordship may.
This is vigilance case.
Yes. It's a fresh matter.
yes
Give the particulars so that we will see.
I will give the number. 556 of 2023.
FIR up for which year?
Sorry, Millers, right now I don't have the brief. I
Roughly-
should have.
Roughly maybe.
A decade before, Millers. Here, before a final bill was paid to the contractor, a vigilance case was instituted.
criminal appeal 2017, Lordship. 2017, Lordship, the appeal hearing. They already ready, paper book has already been ready, and the written note already submitted, and
That
ready
matter-
for hearing.
That matter is
2017.
hard by my lord
Please.
Justice Sahu, and it will take time. You call this
I-
sange- nahi, nahi,
Not yours. If you want, great problem. for you.
appeal, seটা সরকার DA case. DA
না
case
না
your
DA
lordship.
case না এটা misappropriation.
Sorry, that misappropriation case. Then it will take time. ସେ
DA
ଯୋଉଟା
case
କହୁଛନ୍ତି
ନୁହଁ।
ତାକୁ ସାଙ୍ଗେ ସାଙ୍ଗେ ସବୁ ତ ସାଙ୍ଗେ ସାଙ୍ଗେ ସରିଯିବ appeal case
Technical-
ସରିଯିବ।
ସାଙ୍ଗେ ସାଙ୍ଗେ କୋଉଟା ସରିବ?
ତେଣୁ
ସରିବନି।
ଏଟା ଛୁଟି ପରେ ସବୁ ଆସୁ ସତର ମାସ
Appeal can't be heard like this.
Lordship.
It needs a hearing.
because it will set a precedent.
You give, but why should you get the preference over the matters which are already pending long back? What I'm
Suffering
thinking
from
is- I'm
dismiss
thinking
from
in
service.
seniority basis, let it come. And you
2000
cooperate so that we will dispose of. couple
Yes,
of
Lord.
appeals.
That's it.
Let it come
2017.
on seniority wise.
What I suggest, my lord.
So seniority wise, subject to the condition, paper book is ready.
Yes, yes.
That will be better.
Paper book.
That
But you get the list. Which are the matters where the paper book is ready. As per seniority, you fix.
really it
Yes,
can be taken
2000
chronologically.
2015 you're
Otherwise, everybody will mention, we
that
pick up something and the other people are agreeing.
And what I suggest, my lord, so the vigilance cases are concerned, your lordship may fix up a particular 1 day or 2
1
day
day or-
on every week. That will be
That is
better.
not happening, you know, you.
That's
also,
I am
not-
saying. It's good. I ସବୁ ଯାକ
ସେଟା
ଦେଇଛନ୍ତି
ସେଟା
ସେ
ସୁବିଧା ହେଇଯିବ ଗୋଟେ
One day we'll hear revision,
Yes.
the other day we'll hear the
Appeal.
At least 2-3 appeal we can, you know.
हाँ appeal से Friday को appeal
3 o'clock, we'll fix 3 o'clock whenever the appeals have to be heard.
yes yes
हाँ
Lordship.
हाँ
Item 51 from the list. And it's paying for one adjournment. One is after that.
51 adjourned.
Item
Press matter,
Well, after notice.
who is the other side?
Other side is the state.
Day 2.
Item
Interim order,
No,
item 68 and 67 and 68, my lord.
what happened?
My lord, Mr. Sorangi, when there is bereavement in the family, my lord, Mr. Sorangi. And the interim, my lord, interim order is there, your lordship, ma'am.
There is a bereavement in the family, land comes for the accommodation, adjourned.
Lordship, I may be
Interim
excused.
order to continue.
Lordship, I may,
67, 60.
67, 68, ma'am.
Lordship, I may be excused. It's a cancellation of bail matter.
Give it.
Yes.
It will be next week.
May I pardon to mention
Cancellation
item
will be
60.
next week. Monday, Tuesday, Wednesday. Yes.
Lordship, item 60, I am for the opposite party. And it taken up 2 chapter.
Where is the petitioner?
Petitioner concerned.
No,
Inform.
don't do that. The
Let's see,
petitioner will
item
come
number-
and shout. No. You bring him. You bring him. No problem.
Let's see, item number 44.
Keep it, mark it. Whenever the matter is taken up, we will adjourn it. But yes,
Item number 44, praying for an adjournment.
press matter.
Let's see.
Very good. Yeah.
I have pardon to mention, my lord, the one serial MC matter, my lord, that has been specifically adjourned to.
Give the memo. Specifically urgent matter, we'll see. Give the memo. Okay. Come on. Item 3. Yes. 3, what is this?
My pardon, my lord. While you are never judgment. In this case, my lord, accused person is a old sister. Our informant is a old brother, also above 85 years. My responsibility, this case for passing of a FIR, my lord. Notice gale bhai bonko bhitere settlement ହେଇଯିବ.
Who is the opposite party number 2?
Brother, my lord.
They are brothers. What are the offences?
Offense, my lord, ଅଛି 506 294.
Oh. They are brothers. Issue notice.
Only notice, my lord.
ଆଉ ଗୋଟେ no course of action ଥାଉ ଆଉ କେହି ଚାଲି ପାରୁନାହାନ୍ତି ଭାଇ ବି ଚାଲି ପାରୁନି ଭଉଣୀ ବି ଚାଲି ପାରୁନି ସବୁବେଳେ above 8 years
ଚାଲି ନ ପାରିଲା ପରେ ବି ତ କ୍ରାଇମ କରୁଛନ୍ତି।
ଜଲ୍ଦି ରେକର୍ଡ ସରିଯିବ।
ଚାଲି ନ ପାରିଲେ ବି କ୍ରାଇମ କରୁଛନ୍ତି।
ଏଇ ପାର୍ଟି ତୁମେ ଘରେ ଭାଇ ଆସୁଛି ମତେ ଖାଇବାକୁ ଦିଅ ଭଉଣୀ ବିଧବା ହେଲେ ତାକୁ ଦେଇ ପୋଷି ପାରିବ
See, they are very old people.
old people, my lord.
Ragala sir, very old people. But I will not pass coercive action, no coercive action, because that is not my jurisdiction. You tell me what else I can do.
not to
You are not on bail.
my lord.
You are not on bail.
ବେଲେ ଯାଇନ ଚାଲି ବୁଲି ପାରୁନାହାନ୍ତି କେହି ବେଲେ ଯାଇନି ବାବା ଭାଇ
ଫଟୋରେ ପଳେଇଥିବେ ଫଟୋରେ
ନାଇଁ, ନାଇଁ,
ଫଟୋରେ
ଫଟୋରେ
ଫଟୋରେ ଆଜିକାଲି
ଖାଲି
natural ଫଟୋରେ
ନୋଟିସ ଯାଉ ମାନେ ନୋଟିସ ଯାଉ ସେଟଲମେଣ୍ଟ କରିଦବୁ।
These are I'll say the proceeding.
My lord.
Investigation is on.
Investigation going on.
Oh. Investigation.
FIR को आसार କିଛି ଅସୁବିଧା
I'll
ନାହିଁ।
issue notice, I'll keep it next week. You try and serve and bring them, we'll quash.
My lord.
That's the best way.
My lord.
Issue notice to the opposite party number 2. Put it next week, Friday. You bring the brother also.
My lord.
If they can't come because they're very old people, let them appear through VC
My lord.
and we'll see and quash.
My lord.
Okay.
Item 4.
Please, ma'am. My lords,
Yeah.
the petitioners before my lord seeks the indulgence of this court, my lords, thereby challenging the order at annexure 1, my lords, the refusal of 311 application, my lords. Lordship may see the body of the order, my lords, wherein it has been.
Annexure 2.
My lords, annexure 2, pardon.
Yes. What happened?
Lords, the conducting counsel was ill, my lords, and on the day of examination, a prayer was sought for.
311.
My lords,
You move 311.
my lords. Case under section 3.
Counsel have lapsed a good amount of time only to delay the process. Or who is that? This PW 16?
IO.
IO, my lords.
IO, my lord, examined in the year 2021, my lord.
Thereafter, my lords, we filed in the
Where
same
is
order.
your application? Let us see the application.
Application there.
What is the reason you have given?
Application 9, deposition.
The application, my lords, the deposition, actually, we had not cross-examined, not a
You
single.
have to show your
And-
oral statement will not make.
Yes.
Where is the application under 311 and where is the deposition of PW 26?
26.
You file.
I'll
Then
get-
consequently, the petitioner seeks leave of this court to file the application. He moved under section 311 CRPC and the deposition of PW 26 within a week. File it and so that we'll.
Great.
Item 5.
May I please, Your Honor?
Yes.
Passing of Cognizance challenge on the ground that, my lord, the FIR was lost in the year 2011 under section 395 IPC related to section 25 arms at, my lord.
Yes.
And
Cognizance का CS टा देना, charge sheet देना.
against unknown.
Charge sheet देख रुका. Cognizance का charge sheet.
Where is the charge sheet? Copy of charge sheet is
Charge
required.
my lord.
When you challenge, I have been telling you, when you challenge the cognizance order, the minimum first document is the charge.
Charge sheet.
Because the cognizance is taken on the charge sheet, not
Well.
the FIR. Where is the charge sheet? File a copy of charge sheet. Then consequently, the petitioner seeks an adjournment to enable him to file the copy of charge sheet.
With me, my lord.
Let him adjourn the court. Yes.
One date, man.
On date, he'll give date, don't worry about. Yes, next.
Item 6.
I'll file back tomorrow, my lord.
Yes, yes, fine. Yes.
6.
My lord, pass over.
Passover.
Item
Today,
7.
Passover may not
Passover
be
of-
taken up. We have
Hearing matters are
simply
there.
adjourned- simply adjourned. I requested that. Yes.
Item 7.
Pass over, next ask. How the next?
You are
How the
from-
next? I have to take instruction.
Mr. Maharana, let us counsel for the, Mr. So-and-so, appearing for petition seeks, Passover. Mr. Maharana, let us counsel for the, respondent, submit that, he needs, time to the section in this matter, urgent.
Item 8.
Yes.
Item 8.
None appears in the interest of justice, urgent.
Item 9.
May I please, Your Lords? My lord, I have filed this application for quashing the proceeding, my lord. And the FIR has been lodged under section 376 clause 2 clause N, 376 3 of the Indian Penal Code, read with section 6 of POCSO. In this case, my lord, out of law of affairs, the victim was
Wait, I am adjourning it to second week of May.
my lord.
I have reserved a judgment. It may help you, may not help you also.
My
I'll pronounce the judgment shortly
my lord.
and you take advantage of the judgment if possible on the facts of your case.
But that is
I'll
not
just briefly adjourn it. All these matters I am adjourning.
Box Act.
My lord.
Box out.
Oblige, Your Lords.
Second week.
Item 10.
My lord, my senior Bijagam Parada is very ill. Kindly pray for 2 weeks after.
2 weeks. 11th. From 11th. None appears. In the interest of justice. Item 12.
Arjun.
May I please your lordship. The petitioner challenging the petition filed by 205 series petition by the court below, same is rejected. Kindly see the page 11, order dated 1/2/24. 1/2/24.
Okay.
Page 11.
Yes.
The petitioner is the businessman, he is the partner of a Gayatri Oil Corporation.
1/2/24. Yes.
24.
Ready.
On behalf of the accused, 205 persons praying there and dispense with the personal appearance of the accused on each date of posting. When bail was granted, it's directed to the JMFC to appear each date of posting. And the
You are on bail.
Yes.
What is the problem? Why can't you appear?
370 is there. 317 is there.
Each date, petition a businessman, he's moving, traveling all over India for his business.
While committing crime, he should have thought it will create problem. Now I can understand if you are not in bail.
I am in bail.
Understand. Now you are on bail. Appear whenever on that particular day. If you have a problem, you move an application. You can't be
Each date it's not. It's difficult to appear each and date.
Every accused has difficult. Doesn't mean that the trial will not.
317 is there, my lord.
376 there. Please try to understand. You whenever there is a problem in a particular day, you can move application. Who stops you?
Yes.
In a particular day, you can move application. Not that you need the permanent exemption. I am just recording.
205
the
allow-
application. The petitioner has challenged the order dated 1/2/2024, whereby his application under section 205 CRPC has been turned down by the court below. The Learned Counsel, the petitioner submits that the petitioner is a businessman, so therefore there is he has difficulties in appearing in each and every date. In the each activity date. I am not inclined to interfere in this matter. However, whenever in any date of hearing, if the petitioner has any genuine difficulty, he can very well move an application for exemption from appearance on that day, stating the reason for his absence. If such application is moved, the court below may consider the same on the merits of the application. This liberty. You move application, genuine reason is that they will exempt.
Offense, the minor offense, 304
Is your accident or something?
obligement.
317 they pariyo kisa sir.
300 or move an application under section 317.
Yes, my
এটা না ফাইল করি সেটা সে কন্ডিশনটা মডিফাই করে ফাইল
Modify করে
বাস এই স্টেট পারফরম্যান্স টা আউট
how much
I have modified.
exactly.
objection on 317 petition filed.
I have written
Yes.
either 317 or you move an application for seeking exemption on that day with genuine reason.
Yes.
Both the things.
Okay.
13.
May I please, Lord, sir? I have challenged the cognizance order, my lord, dated 7/1/2023, my lord,
Yes.
where the offenses are 317, 392 and 411, my lord. The crux
Where
of
is the charge sheet? Let us see.
yes, my lord. Charge sheet is at
What are the allegations?
I am the receiver of stolen property, my lord.
Then why should the cognizance will be worse?
Because my cross of the case is that on the date on 21/8/2022, my lord, the main accused has stolen a car, and FIR has been lodged in Sadar PS case number 366/22, my lord.
Yes.
By using that car on the same day, my lord, he has snatched away 2 Mangalsutra at Salepur. Another FIR was lodged before the Salepur police station, that is 259/22, my lord.
And all the stolen property is given to you.
Yes, my lord.
Then
The only stolen property has received by me at the 40,000 rupees, my lord.
311.
311,
Right.
411.
411. Right.
In Sadar PS case number, where the car stolen FIRs are there,
What is wrong in cognizance order? You tell me.
I'm saying, my lord,
Yes.
in that case, the main accused has been arrested, my lord.
Yes.
by confession statement, my lord, my name has been here, and I was also arrested. My article has been seized, and I have put to behind the bar, and I have been released on that case, my lord. Subsequently, my lord, in this case, same allegation, same FIR, my lord, I put to trial, my lord. Where already I have recovered, my articles have been recovered in that case, my lord. Also in this case, also 392 and
I don't know how
411.
many cases with the stolen property you have taken from how many people?
No, my lord, only this. Though I have no antecedent at all, my lord. Against, except two.
You are a businessman.
Yes, my lord. I am
Business up for taking stolen property.
Now, 366, Sadar PS case 366 2022 is there against him. For that is
You argue on charge. I am giving that.
anticipatory will also rejected.
In this petition, the petitioner has challenged the order date.
Your lordship, my 205 petition.
I am just giving order dated 7/1/2023, passed by JMFC Salipur in connection to GR case number 738 of 2022, arising out of Salipur PS case number 259 of 2022. Whereby the land court below has taken cognizance for offence under section so and so. I inclined to interfere in this matter at this stage. However, the liberty is granted to the petitioner to raise all the points at the appropriate stage before the court below. Before the court below. With this liberty, the present petition is disposed. Yes.
My lord, I am not on bail, my lord. I am not on bail.
Absconded.
Absconded.
I know that is the reason you have come. Therefore, I am given liberty.
Main accused has been arrested and.
Do you know that this is not a bail court?
Yes, ma'am.
This is 482.
Yes, ma'am.
Cognizance order I have to see. The cognizance, according to me, prima facie case is made out.
Yes,
if you say this charge is not made out, that charge is not made out, then you have to go to the court where the charge has to be framed. You won't argue. If the charge is not made out, you will be discharged. I have given that liberty.
205 petition may allowed me to move before the court
No,
below.
don't I can't extend the jurisdiction of 482.
Main accused has been released on bail. The case has been split up, my lord.
It's all right. You go and seek bail. Yes, next. 14. Yes.
May I please, your lordship? That in this matter, your lordship, the petitioner is challenging the order passed by the London JMFC. Though he has certain writing the custody of the child in a section 97 petition, your lordship, filed by the father. If your lordship will turn to page number 13, your lordship, third line from the bottom, your lordship. This court agrees with the plea of opposite party that the court does not have the
13, 1-3. Yes.
My lord. Third line from the bottom. This court agrees the plea of opposite party that this court doesn't have the jurisdiction to decide the custody, but it is the office who should go for the proper court for a custody of the child. What has happened in this matter? The petitions are the maternal grandparents. The mother of the child expired in 2013 in December, your lordship. The child was born in February. The mother expired.
This application you have moved? What application you have moved?
I have moved. There's an application. 97 application is moved by the father of the child.
Yes.
To take the custody of the children.
In that 97 application, this is moved.
No, 97. It should instead of going to the family court, 97 is just
section
like
12. You have to file application under section 12. 97. Let us see what is
97. I have already quoted the section also in my petition, your lordship. It's not a criminal case, your lordship. It's not an illegal confinement of anybody. After the death of the mother, moreover, the father is a
child was with you.
Child was with me because
you are the grandparents.
Maternal grandparents. What happened? The father is physically handicapped. He's a deaf and dumb person. Now the child is of 1 year, just 12 months baby. So now he is saying with the father, grandparents. Now this father is moving an application that and the court is directing that to give the custody.
What happened to the mother?
Mother is expired.
Oh.
Mother is expired.
Issue notice to opposite party number 2, returnable within 2 weeks. In the international child is with you right now.
Yes, your lordship.
The land counsel for the petitioner stay. Don't Mr. Ragada, we will not displace the child at this stage because the great mother and father she is staying. What is the age of the child?
Child is 12 months only. It's his.
The law is
mother died.
Law is well settled.
Law is well settled after death of the mother, my lord.
The natural guardian is the father, my lord.
That's right.
But if father doesn't wants to take, my lord, then only.
But it was,
You are correct.
My lord,
But you are correct. Just see, he is defendant.
yes,
He is alone.
alone.
Wife
His
is not
family
there.
members there, my lord.
No, nobody is there. So therefore, at that point of
What is
time,
his statement? I am issuing only
My lord,
notice.
notice, my lord.
And the child is with the grandparents.
grandparents, your lordship.
Nana Nani.
Nana Nandi, right.
Then let her be there. We
My lord, both parties will come here.
Mr. Dividi, let us submit that the child is of 12 months. And the boy or the baby girl.
Boy, baby boy.
The child is in the custody of the maternal grandparents of maternal grandparents. The opposite party number 2, who is the natural father of the child, had moved an application under section 97 of CRPC, in which the present the impugn order is passed. Mr. Dividi further submits that the opposite party number 2 is a deaf and dumb
Yes, your lordship.
person and physically handicapped, so he cannot take care of the child. Taking into consideration the aforementioned, in the internagnum, taking into consideration the aforementioned, the operation of order dated
16th of
2024 remains stayed till the next date.
My lord, deeply obliged.
Yes.
15.
Yes.
My lords, hypothecated vehicles, 100% financed, have been attached to the charge sheet, and my lords, I am accused. I am a private person, my lords. And only connection that the vigilance department finds, that a SIM card was used by my wife, the accused wife, the suspect officer. That is the only link. No CDR, no registration papers from the RTO office, and it's admitted in the charge sheet. There no information from RTO. 4 vehicles, my lords. I am, my lords, Anil Tomar. I own trucks, my lords.
Have you moved an application for
My lords, not released, my lords. I moved an application for discharge. It is rejected, my lords.
Okay.
And I am challenged the charge sheet as well as the order, my lords.
Against
My lords, 100%, my lords, 100% financed vehicles, my lords. Zero down payment.
The allegation, let us see.
The allegation is that, my lords, I am the Benami holder of the suspect officer of 4 vehicles, my lords. Of 4 vehicles with 100% finance, my lords, I'll show on record. And by IndusInd Bank, Tata Finance and HDFC.
Who are you?
My lords, I am the truck owner, my lords. I am accused 7 in the charge sheet, my lords. 2010, the search was conducted. 2012, the charge sheet was submitted, my lords. No mention in the FIR. Even in the charge sheet, my lords, there is no document. 196 documents are there.
Where is the impugn order?
My lords,
Impugn order is there?
my lords, I'll take lordships first to the FIR lordships.
FIR.
My lords, may kindly come to the movable assets. Page 19.
Yes.
My lords, no mention of the petitioner, my lords. I have gone through very carefully, my lords. I am making a statement. No mention of the accused.
The truck is not there.
No, my lords. Then, my lords, may come to the charge sheet, my lords. Charge sheet, my lords. A7 is Anil Tomar, page 32.
1 is 32, 1 is 2. Yes. Yes.
And, my lords, may come to column 12, my lords. My lords, I'll take to the details of the properties, my lords, at page 38, my lords.
Yes, I am there.
My lords, not a single document, my lords. Out of 196 documents, nil. Not a single document pertaining to the trucks of Anil Tomar.
Yeah, what is the allegation against you then?
My lords, I am the Benami holder. The 4 trucks belong to the suspect officer.
Who is suspect officer?
One Nagendra Prasad Nayak, my lord.
Co-accused with you.
Yes, my lords. 12 accused persons. I am the 7th accused. And my truck, still I am owning the trucks, my lords. Some of the trucks are with me. I am a transporter, my lords.
So far as this petition is concerned, that I do not know whether charge has been framed. Perhaps in the meantime, charge must have been framed.
Charge has been framed, my lords.
Where is the bank documents from?
My lord, I'll show them my governments.
And the fully financed documents.
No. Fully
are there. Yes.
4 trucks, it cannot be fully financed.
My lords, fully financed, my lords. My lords,
It is his submission.
No, my lords, not my submission.
The bank document.
Bank document, your lordship kindly see.
My lords, may kindly come to page 73 of the charge sheet, my lords.
No, I show me the bank document.
My lords, kindly be with me and page 73, part of the charge sheet, my lords.
73.
Column 21 to 24 are the 4 trucks that I own.
73.
73, my lords.
74. Yes, 73.
My lords, may kindly see column 21, 22, 23, 24.
Yes.
My lords,
21.
there is a remark in the brackets. Taken as per the quotation price in absence of reply from concerned showroom and RTO. My lords, this is the charge sheet, my lords.
21.
21, 22, 23, 24, all same remarks. And they are my trucks.
Taken as per the quotation price in absence of reply from the
Concerned showroom and RTO.
RTO.
Even there is no correlation between the registration by the investigation with me. The RTO has no reply. Then, my lords, I'll take lordships.
If there are conflicting facts, then I'll not interfere.
No, my lords.
Show me that these three
My lords, I'll
these three vehicles, Tata Motors.
My lords, I'll take. My lords, I'll take you that.
Goods, heavy goods vehicle.
My lords, I'll take directly to you, sir.
Show me the what you call the documents pertaining.
My lords, may come to page 90.
Cost is, I'll tell you, the cost is 9 lakh.
9 lakh.
Show me.
And one more discrepancy is that they have 4 trucks in the charge sheet, and same charge sheet said expenditure on 5 trucks. Same charge sheet, man.
Let us see.
My lords, may come to page 90.
These 3 truck heavy, what is that?
Mas
Heavy
this
goods vehicle.
10 wheelers, my lords.
10 lakh rupees, you show me.
My lords, you
have
come to
taken the
my
loan of 9
lords,
lakh.
please come to page 90.
90.
90, annex
Yes,
4.
I'm there. At the top, where is your name?
My lord, the vehicle name Anil Tomar is mentioned below HDFC Bank, lordships.
Yes, Anil Tomar, right?
My lord, the name of the financer, 3-4 lines below that Anil Tomar comes HDFC Bank Limited.
Yes.
My lords, may just come to the right hand side. Amount finance 10 lakhs 19,000.
See, the vehicle numbers are there.
Yes, my lord, vehicle number is there, man.
The same vehicle?
Same vehicle, lordships. I am making statement, my lords. I have checked it. My lords, may come to the right hand side. Amount financed 10 lakhs 19,210 rupees. Amount disbursed 10 lakh 18,542.
Yes. This is one vehicle.
This is one vehicle, my lords. My lords, then page 94.
Yes.
Now another vehicle, my lords. Similar 10 19 210 10 18 544. Then my lords, page 98.
Yes, Mr. Marana, what do you say?
Your lordship, kindly see page 86. Those documents are the annexed documents are not part of the prosecution evidence.
Suppression, my lords.
It is not part of the charge sheet. Your lordship, kindly see page 86.
80?
86. That is the registration number. Your lordship got it.
Yes.
Registration number OR that truck.
OR 17A
6708.
Yes.
That is in the name of your lordship, owner's name, Sumita Jha. The petitioner is something else. Petitioner name is some Thamar. Your lordship got it. Next line, owner's name.
Now, if Anil Tomar has taken the loan and purchased the vehicle, how
Then your lordship kindly see. The Odisha Transport Department Registration Authority, the document they are relying, their own document. Then owner's name is Sunita Jha. Then your lordship turn to financer type, right hand side.
My lords, he is not reading one more line. Previous owner is Anil Tomar. This is second purchase.
ठीक ଅଛି ଟିକେ ଦେଖନ୍ତୁ ମୁଁ କହୁଛି financer type nothing
where
right hand side
yes, financer type.
hypothecation detail found financer type.
Who is this Sunita Jha?
Second
no. That is their document.
No, what is his case is he purchased it and he sold it to Sunita Jha.
Now he is saying that it is with him.
Whether Sunita Jha is an accused.
No, I am not saying it is. This vehicle has been sold.
So why I am saying it's an offense, including 120B. Your lordship will go through that charge sheet. Your lordship will find how connivingly, in conspired with all number of, in a DA case, your lordship must be astonished that the 14 number of accused persons. He is a police officer. in connivance all businessmen has acquired assets in their name. And when we
No, you just answer me one thing. Whether this Anil Tomar is made as an accused on the strength of these three vehicles.
on the basis of 4 vehicles. And
He is showing the document that all the 3 vehicles he has purchased by
finance.
100%.
So it's
and how will you connect Anil Tomar with this crime? Only on the basis of the fact that he is the Benami.
no, that is not the wife of the main accused using the mobile phone and SIM card, which has been the name.
Situation enemy's friend is
No,
my
that
enemy.
is not. I'm not on that.
I'm only on one thing, my lord.
movie जो mobile use
When
करता
this
है,
36 lakhs,
1 minute, let it-
Monar में जो mobile मुझे use करता, that is not in that way. I cannot be implicated as an accused.
Maybe Anil Tomar's friend may be the real accused. He may be a friend. But
acquaintance,
Your Lordship, kindly visualize. Thing is that the mobile phone SIM card using by the wife of the main accused, that has been, it's a postpaid card. All along the payment has been made by this person. The connection is a Benami. When the question of Benami comes and 120B is there, so it's a matter of trial, because it's a conspiracy, always has in secrecy. So at this stage, whether now the document
merely because the main accused wife is holding a mobile and there is
mobile
number, and he is paying that all these things.
No. There is
what about the amount which is financed by Tata Finance, HDFC in the same way?
You file your response.
And another aspect is also whether charge has been framed, I do not know.
Get instruction. We have to examine it. This is very dicey.
Because I cannot go beyond the evidence.
2020 judgment of Supreme Court, my lords, just they said that hypothecated hire purchase, they are hire purchase vehicles, my lords. They are not my property even if it is Benami.
What are the other materials like the SIM card and all? What are
my
the
lords,
other
only link, there are only two paragraphs, one para in FIR, the other para in charge sheet, saying that as because a postpaid SIM card is recovered from the wife of the suspect officer, so the 4 trucks belongs to the accused suspect officer. And my lords, if that is the argument, my lords, I put it to myself, then his house and building also should have been taxed.
His point, I understood.
SIM card
and my lords, one more thing, my lords,
I understood his point.
One more thing, I have not financed it from any Tom, Harry, Dick type of finance officers, my lords, or any agency, my lords. They are in the bank. I couldn't influence them.
I am saying so. The document they are relying now.
Anyway, we'll examine it. We'll just issuing notice, get
this is gross
whether charge is framed or not, and what are the other materials, sir.
And my lords, one more thing, my lords, out of 196 documents in the charge sheet, my lords, not single document connecting the vehicle with this accused. Not a single document, my lords. No bank document, my lords, no RTO papers, no CDR, nothing.
Right down. What have you challenged?
Well, I have challenged the discharge order as well as the charge sheet.
No. The thing is that I have to take instruction whether charge has been framed. If charge has been framed, this will go. Because once charge,
no, I have challenged the discharge.
Go beyond that, but it cannot be reversed here in criminal trial.
No, I have challenged the discharge. They rejected. I have come here.
He has to give undertaking whether charge has not been framed or not.
Let him take instruction, lordships.
Right. The petitioner has challenged the order dated 8/11/2023 passed by the Special Judge Balesur on TR case number 33 of 2013, whereby the application moved by the petitioner for discharge from the case has been turned down. Mr. Samantha and counsel for the petitioner submits that the petitioner has been entangled in the present case on the basis of the allegation that four vehicles, heavy
commercial vehicle, commercial heavy vehicle.
The vehicle is alleged to
heavy goods vehicle.
Allegedly is the Benami vehicle, Benami properties of the main accused, which is in the name of the present petitioner. The Mr. Samantha taking me to the document of the bank submits that all the 3 vehicles, 4 vehicles have been purchased by the present petitioner by availing loan from the HDFC Bank.
And HDFC and Tata Finance.
HDFC and Tata Finance Bank.
And 100% finance.
100%.
With only 1,000 rupees margin money.
Therefore, Therefore, the acquisition of the four vehicles cannot be said to be the Benami properties of the main accused. Mr. Maharana, learned counsel for the petitioner submits that apart from these four vehicles, there are other incriminating materials against the petitioner, and he wants to seek. He seeks time to obtain instruction in regard to the fact that whether the charges have been framed or not. Issue notice to the opposite party. Ms. Marana accept notice, returnable within 2 weeks.
Well, is there any returnable date, lordships?
Date he is going to give you a date. So give it exact date. Okay.
Please, lords. Oh, grateful lords.
You bring if any the other material, it's all right.
That I got it, lords.
And you tell me whether these three bank documents were taken into consideration or not.
Not at all, my lords.
So far charge sheet ko charge sheet nahi sir.
My lords, page 77, one more thing, my lords, of your lordship's time. 4 trucks in the assets, 5 trucks in the expenditure, my lords. See the charge sheet. And my lords, income comes from other truck owners to the charge sheet. But this Anil Tomar has no income.
But fact remains that you have bad companies.
I may be lordships. But sometimes, my lords,
company, then
sometimes, but this lordships, I am invoking lordships 482 provisions only because the gross abuse, my lords. 12 years I've been suffering this.
We'll examine this.
And that mobile number which he is saying.
Prima facie, you have a case, let us see.
My lords, one more thing, my lords, that mobile phone which they allege is still used by me, my lords. It was given to the wife of the suspect officer.
Other ଯଦି material କିଛି ନଥିବ ମୁଁ ଜାଣିଛି ହବ କିନ୍ତୁ today morning I was discussing.
If there is no other material, then he is out.
That I don't have anything to say. କାରଣ ସେଟା ସେଇ basis ରେ ହେଇପାରିବନି. କିନ୍ତୁ have to see the connections. Because it's a Benami transaction.
Let them produce that registration paper from the RP office.
Benami transaction, unless you say that this transaction, the money flows from the main accused.
That main accused
document you show.
That 5 criteria I have to
in this case, 100% finance, my lords. Where is the money coming? From Tata Finance.
Standard
and Tata Finance is the Benami holder as per their analogy.
Next.
Grateful lords.
Next. 16.
Yes. Well, I have challenged the FIR being lodged by the informant.
Yes.
In Mohida PS case number 2 dated 1/1/2024.
Yes.
Under section 498, 341.
Have you settled the dispute?
Pardon?
Are you settling the dispute?
Pardon?
Are you settling the dispute? Because
I am a stranger to the family of the husband. I am no way connected. I am residing 2 kilometers from the house of the in-laws of the informant.
What are the allegations against you?
Allegation against me is that I have unethical relationship with the husband of the informant, and I applied some medicine for miscarriage.
So
this certain is there.
Is it not enough for is it not enough for this investigation to be carried out at the stage of
No, it is only was allegation because in the
how do you know investigation is still on? Now the FIR is lost when?
And it has been observed in the ABLFL number.
January this FIR is lost.
Yes.
Some allegations are made against you. Investigation is going on. You want that I should be quashing this petition? How can you?
It has been observed in
all this
anticipatory way that the case diary doesn't contain any evidence of miscarriage or abortion, and the allegation appears to be directed against the husband.
I know. You have been granted. You have been granted bail, and all these things you tell.
Discharge petition.
The FIR was lodged, and the petitioner is challenging the quashing. Petitioner is seeking quashing of the FIR. Mahila PS case number so and so under section. The said FIR was registered on 1/1/2024, and the investigation is still on. Let it counsel for the petitioner by relying upon the observation made by the coordinate bench while granting him bail, submits that no case is made out against him. He further submits that he has sufficient material to show that he is not a part of the family to which the opposite party number 2 belongs, therefore, therefore the allegations are false and fabricated. At this stage, I am not inclined to interfere in this matter because investigation is going on. However, liberty is granted to the prisoner to submit any other document or his case before the IO. If he submit to the IO and furnish the document, these things can be considered by the IO. Considered by IO. With this liberty.
Only sir, the relationship is my husband used to drop my child in her house for tuition.
Whatever, sir, FIR is lodged just now, investigation is going on, you are on the bail, how can I quash it? I am just giving you liberty, whatever material you have, go and give it to the police, police will take care of that. Police may file a closure report in your favor. Go and, I gave that liberty to you. Yes, next. 17.
Ma'am, Judicial Lordship, my lord. I am challenging the order of cognizance, my lord.
Yes.
Case of the petitioner, my lord, whether, my lord, two cognizance orders can be passed in different offences in one case, my lord, by the same court, my lord.
Sorry, two
cognizance orders, separate cognizance orders can be passed in different offences in same court, my lord.
Where is that?
My lord, kind of
You are
like
challenging
Annex 3, my lord.
April 2023. 3.
Yes, your lordship,
Yes.
running page page 31, your lordship.
Yes.
Then relevant portion, my lord,
Yes.
running page, my lord, 32, order dated 28/2023, peruse the complaint petition, initial statement of the complainant, statement of the witness recorded 202 CRPC, FIR, charge sheet, statement recorded under section 161 CRPC and other connected documents submitted in PS case number 467 corresponding to GR case number 1164 of
Next,
particular against me.
Next, what happened?
Milord, can I glance, Milord, Annexure 1 and 2, Milord. Case, background of the case, Milord.
No, where is the second cognizance?
Second, Milord, I am coming, Milord.
Where is that? You show me.
Your lordship.
Which page?
That is not with me, Milord, but in one kind of glance, Milord.
That is your only
Connected
point.
with-
You don't have. You don't throw
Lordship, for a-
papers like this.
For a moment, Milord.
File.
In connected case, Milord, learned court, this honorable court
Right.
has
Where is the
observed.
order? Where is that order whereby you are saying that the cognizance is once again taken by the court?
Another
Where is that order?
That is not with me, Milord. It is on record, Milord. For a moment.
Where is the record? Record is with me. Where is the record? Your record. I need to see your record and I will see my record. You file that down.
Your lordship, for a moment, Milord. Your lordship, for a moment. Initially, case was registered for the offence.
See, cognizance is taken against the offence, not against the.
Against offence. Yes, about on your
And
lordship.
if the cognizance is taken in a split manner in 2 phases, there is no wrong in it. What is wrong in it?
Milord, so far as the husband is concerned, Milord, cognizance was
Separately
taken
taken.
306, Milord. On the basis of complaint petition, that means protest petition, Milord. So far as the other in-laws members is concerned, Milord, cognizance was taken, Milord, 302. That is the difficulty. It is entire purely depends upon point of law, Milord.
So let's display another cognizance order, my lord. It's
Where
barely
is your
necessary.
302?
302, Milord. For
302 you have, where is 307?
cognizance has taken. Your lordship.
No, don't give them. Bring it on record. Please bring it on record. You have a.
Annex
you have a-
2, your lordship. Annex
And where
2.
is this NBW
Your
order?
lordship, Annex 2. Annex 2, charge sheet, Milord.
Yes.
Charge sheet was submitted, Milord.
You are not trying to understand.
Yes, your lordship.
As per the charge sheet, the cognizance has
What's-
been rightly taken.
Taken against husband, your lordship.
Husband.
306, Milord.
306.
On the
And you are agreed by the fact that on the basis of the same charge sheet, cognizance is taken against you under 302.
302.
That's what you-
This is the
Where
contract.
is the cognizance order whereby cognizance under 307 is taken? Where is that order? You file that order. And what is this NBW order?
Enrollment Annex 4, your lordship.
Now NBW has been issued.
Yes, it.
The best course would be I'll stay the NBW order, go before the trial court and argue all these points at the stage of
Framing charge, your lordship.
That's the best course. Don't invite any finding at this stage which will create problem for you. I'm staying this order of NBW and giving you liberty, go and argue every point before the court at the time of framing of charge.
Obliged.
Okay, right on. You have not appeared before court or what?
Yes.
You are on bail
No, my lord.
earlier? Right on. The petitioner has challenged the cognizance order. Dated, order dated 20th April to 2023, passed by whom?
Learned JMFC Khali Court.
Learned JMFC Khali Court in ICC case number 4 of 2023. The consequent petition submits that on the basis of the same allegation of the same charge sheet, for the husband.
No, my lord. The present petitioners are in-laws, my lord.
In-laws. And
another one?
307 against whom?
306 against husband, my lord. In-laws against 302.
For the husband of the deceased, offences under.
My lord, there is two petitioners.
Cognizance has been taken for offence under section 306 IPC. Whereas on the same charge sheet and allegation, the cognizance against the present petition is taken under 302 IPC.
And other allied offences.
And other allied offences. I'm not inclined to interfere at this stage. To upset the cognizance order. However, liberty granted to the petitioner to move before the related trial court at the stage of framing of charges and argue all these points. Okay. At this stage, the consequent the petitioner submits that by order dated 12. Where is that?
12/10/2023.
NBW has been issued against the petitioner. On instruction, he undertakes that his client should be appearing before the court below on 30th of May 2024, and the remedy available to them under law. In view of their submission, the NBW issued by the JMFC Khali Court on 12/10/2023 is set aside, subject to petition appearing before the court below and moving application as per law. I have set aside, go appear.
Direct.
Next.
18.
May I please for a loss?
My lord, the petitioners are the petitioner number 1, the father, and petitioner number 2 and 3 are the son.
Yes.
And the allegation, my lord, during Bharat procession in the village, my lord, there are quarrel between informant son and the present petitioner. The present petitioner number 1 arrested and released on bail. 2 and 3 were on anticipatory bail. Thereafter, investigation completed and charge sheet has been submitted. The matter of 2017. Your lordship has a glance offence under section 307, my lord. And in the meantime, matter has been amicably compromised between the parties, so that I am added as an opposite party, number 2 to the informant, my lord. And your lordship have a glance in the medical report of the at page 36. There is injury, my lord, lacerated wound over the left wrist. In the patient was disoriented, irritable, and alcoholic. After primary treatment, patient was referred to SCB Medical College, and injuries are simple, hard and blunt weapon within 6 to 10 hours. And SCB Medical also confirmed the DHS.
What do you want?
My lord, one thing your lordship will request, or I will appear before the London court below. The NBW has been issued against the present petitioner because the present.
What do you want? You tell me.
If your lordship stay the proceeding, notice to the opposite party, or
Have you settled the dispute?
Yes, my lord. For
Call
that,
them, I'll quash it. Monday, you call them here. I'll quash it.
my lord, your lordship, otherwise I will give evidence before the London trial court in Jagatsinghpur.
Why you call them? You have settled the dispute. Simple injury, 307, maybe 307. I'll quash it. Call them here.
Actually, is there any compromise in real sense?
You have settled the issue,
Yes,
compromise,
yes.
bring them. Bring them here, I'll pause it. Forget about 307. Bring them.
Lord, call it on April,
Wednesday,
next one, next day.
Wednesday,
25th, your lordship.
25th. Call the accused
My lord.
and the informant and injured. Injured, who is the injured, who is the informant?
Lipuna is informant son.
Same informant is the injured.
No, informant son. Informant is a lady, my lord.
Then you implead the informant.
Informant is a party, my lord. Opposite party number 2, my lord.
Who is the injured?
Injured is her son.
Injured also, you would make injured also party.
Man,
Bring injured also. In 307, if you want a quashing,
man,
and not only informant, the injured is also has to be there.
man.
To implead injured, land counsel for the petitioner seek permission to implead the injured of the case as the opposite party number 3. He may do so during the course of the counter sign. Sign it, do it.
Man.
And bring both, all of them.
Man.
Here. That's it. Okay, next.
Item 19.
Okay. Petitioner filed this case challenging the rejection of the discharge order by the annexer 11.
Who are
page
you?
54. I am the accused man. The petitioner and opposite party one is the brother and sister. The opposite party has filed a complaint case against the petitioner that I am making the first and receive the land acquisition money from the land acquisition officer.
What are the offences?
Offences under 420, 467 and 468. There is the documentary evidence. The opposite party number file also filed a partition suit before the learned civil judge senior division Kamakya.
You are related.
Brother and sister, madam. Sister has.
Why don't you settle?
My sister has filed this case for
Shall I send you to mediation, or you will bring them so that we can see it can be passed? Brother, sister, and
your lordship issue notice.
Issue notice. It will issue notice to the opposite party number 1.
And learned court will fix the date for charge on 18.
You move application saying that it is sub judice. Yes.
The date may be fixed.
Yes.
Item 20.
Maybe. Yes.
The petitioner challenged the rejection order of petition of STGM PAN case. Dated on 12/3/20.
What happened?
205 petition rejection of STGM PAN case.
What is wrong in it?
138 NIF.
You are accused.
Man,
What is the check amount?
5 lakhs.
Where is the order?
My lord, page 26.
Yes. Yes. Appear through VC. Appear through VC.
Man.
I'll simply issue notice, Lada, 5 lakhs, but be ready to pay the amount. Issue notice.
21.
Lordship, one pass out because all the parties has come. A family dispute.
Offense?
Offense 306. सिर्फ किरोसिन ढाले की मरिगला. That is the allegation. निजे जे आमे किछि ताको कहिलु यार सुन that is the allegation. Lordship may see that.
But 306.
Fact how to do. Se कहजन से. हां yes yes.
Oh, but 306.
What happened, your Lordship? Already they have made compromise annexation 2. Lordship may see.
No, compromise. It may be 306.
हाँ 306 टा के कहूची से.
Why?
ओ झियो.
Why?
Seat, my lord, submitted. Lordship may see this. Cognizance secretary.
Charge has been paid.
Yes.
Where is the charge sheet? What has come against you?
Lordship may see that charge sheet is there.
This is
Yes,
not
yes, charge.
CS number,
I
because
know.
Cognizance has been taken.
But I just want to see what are the allegations in the charge sheet after investigation, what has come against you.
Charge sheet, yeah.
I'll take it up at 2 o'clock.
Yes.
I'll take it up at 2.
Oh, okay.
Yes, my lord, and I will also give you
Yeah,
one
by
of
the time,
decision.
just check it up.
Yes.
If the allegation in the FIR and the charge sheet is
It cannot
more or less
be,
same, then we'll proceed.
it cannot be question.
And the
Act remains, your lordship.
other mitigating facts which you have said in the case of 2004,
4, my lord. 20 years has been
and
passed.
the informant has by now died.
Died. Before
have
death,
come.
my lord, he made a compromise.
Before death, he has made compromise.
Yes, in 2016.
No, the issue is now, since informant is not there, the victim is any case died, and who will support the prosecution? So
My lord, wife is there. Wife.
see, nobody is there to support the prosecution. Therefore, the
Yes.
the trial will be a futile exercise.
Yes.
On that ground, I can
Yes.
also quash it.
But here, his wife is there and one daughter is also alive. They are coming with their legal hair, all original certificate.
2 o'clock, just show me the chart.
Yes. Yes.
22.
May it please your lordship,
Yes.
my lord. Item 22, your lordship. The petitioner before your lordship prays for quashing of this case, my lord. Your lordship may consider that this case, as on the FIR lodge, investigated, charge sheet submitted, this is not maintainable. This case is not maintainable, my lord. The brief fact of the case is that opposite party number 2 informant lodged an FIR that he has got landed property. Now, on that landed property, the government had planned to construct a road under the Executive Works Department, Bhavanipatna. There was a direction to construct a road. Now, that road passes through his landed property.
Right.
And the government constructed a road on his landed property without acquiring the land under the Land Acquisition Act.
Right.
Now, this is the statement by the informant. He has given the tender number, completion of the work order, everything. Now, I am, your lordship, that tenderer, your lordship. I am that lowest bid option tenderer. I am the person, your lordship. I have taken that tender. I have constructed the road.
He says that it was not acquired and you constructed the road.
He says that government has not acquired. The government has directed for construction of road.
Where is that? Let's see charge sheet.
Page 15, your lordship. FIR, I am reading.
Here. No, forget about FIR. Now come to charge sheet. Page 21.
Charge sheet, your lordship. Charge sheet, annexure 2.
Page 21. Come to page 21.
Page 21, your lordship. The brief history as stated. During course of investigation, I visited I am reading, my lord.
Right.
During course of investigation, I visited the spot in presence of witnesses examined. The present witness who proved the occurrence well and recorded the statement under 161 in separate sheet and attached. I seized demarcation report from complainant as well as certified copy of the RR which recorded against Pramod Kumar Singh, that is the informant, your lordship, as prima facie evidence well established under 447, 427, that is trespass and mischief. The allegation is that I have trespassed upon his land
Read
and
read at the top of the first paragraph.
my lord. Brief fact of the case. On 8/1/2019 at 1 p.m., one Pramod Kumar Singh, son of Purushottam Singh of village Korlapat, PS Thuamulu Rampur, district Kalahandi, at post Hilltown, was a written report for the YC Thuamulu Rampur to the effect that
saw a contractor is digging the soil.
My lord.
From his cultivation land.
My lord.
Unauthorizedly, and when he searched about the matter, the office of Rural Department of Bhavanipatna, he knows one of the company, namely so received a tender.
My lord, that is there. That is his case, and he has filed a writ petition, that is 19308/2019 against
what is the fact? Land has already been acquired or not?
The road has been constructed. My lord, I was directed by executive engineer to construct a road.
Land is acquired or not?
Land has not been acquired by the government. If after all, your lordship, this is to be believed, then government is accused. I am not an accused at all, your lordship. I have carried out.
Where is the tender document?
Tender document, your lordship, I do not have, my lord. That I do not have.
Yes, Mr. Rao.
No, my lord, there is no tender document is also attached.
No, that's right. But what is the allegation? Just see.
Yes, your lordship, it is absolutely my lord.
Allegation is, the landowner says that when he went to the spot, one contractor was digging his soil and trying to construct something. And the contractor is here.
Yes, my lord.
And the contractor says that there was a tender. I was the lowest bidder. The tender was given to him. Work order was issued to him for the purpose of construction of the road. What will he do? He will not require the land, then the officers will face whatever. But how he is responsible? He went to the spot on the basis of a tender document.
Yes, my lord.
Show me the tender document whether this land is included in that tender or not.
Yes.
That's the only thing.
I will take instruction.
If in the tender, if the work is given to him, then he's out.
Yes, my lord.
I don't. The petitioner is challenging the 17/6/2019 is the cognizance order.
Yes, your lordship, but I appeared, as per your lordship's order, I got 205 benefit that I have stated, your lordship, on, my lord has been pleased to allow me to go on 205.
Yes.
That is by order dated.
Now you are challenging the cognizance.
Yes, your lordship.
Right.
5/2/2024 only.
Huh?
5/2/2024, your lordship has been pleased to direct that.
Where is the cognizance order? 17.
Cognizance order, your lordship, Annexure 3, page 22.
22, my lord.
Right. Right. Why the petitioner is challenging the order dated 17/6/2019 passed by SDJM Thumalupur
Thuamul Rampur.
No, Thuamul Rampur in CT case number 44 of 2019, whereby cognizance for offence under section 447 or 427 427 only 447 IPC has been taken against the petition. Mr. Mishra, and counsel for the petition submits that the allegation against the petitioner is that when the informant went to the place of the informant, the counsel for the Mr. Mishra and counsel for the petition submits that the allegation against the petitioner is that the informant saw the petitioner digging the soil, digging the soil and trying to construct something, construct in the land of the informant. He supposed that the government floated a tender, and he will the lowest tender. The work order was issued to him for the purpose of constructing the road. On the strength of the state work order, he was constructing the road. Therefore, there is no case of trespass as such made out against him. If you notice the opposite party, Mr. Rahul accept notice for state. Opposite party is the informant, huh? Opposite
Two.
party number 2, the informant.
My lord.
Also, written within 2 weeks. In the meantime, proceeding before so and so is stay. Yes.
Obliged, my lord.
23.
May I please? Here the petition number was granted to the anticipatory bail, my lord.
Yes.
That is in bail appeal number 10906 of 22, 120, my lord, and by the order dated, my lord, 23/3/21, is this one court granted anticipatory bail in the event of arrest shall be released on bail by the arresting officer, my lord. Now, those, my lord, the Lord SCM issued summon against the petitioner for appearance. That is at page, my lord, 31, my lord, on 11/1/21 at, my lord, 12th line from the top, my lord. Gopal Krishnadas is not arrested. Height A bail appeal number so and so, my lord. Now, if you appear with the court below, my lord, the offense is 307. He might not have my lord, granted the bail because the court, the tribal court of sessions, PO7 is there, my lord. So, he apprehends on that, he may be taken to custody.
No.
In view of that judgment, my lord,
In
2011.
You were on anticipatory.
Yes, yes.
That time 307 was not there.
Was there, my lord.
Was there?
Yes, was there.
Then what is the problem?
Now, my lord, someone has been issued the petition for appearance. The
You
magistrate,
were on anticipatory bail. What
because
is,
now if you not appear, then warrant will be issued against him.
why?
Because my lord, someone has been issued for appearance, my lord.
Once anticipatory bail is granted by this court, how can
That is that's understood, but they are not my understanding, because once someone has been issued, then you have to appear. If you appear with the court below that, he has to be released on bail.
Page 32, my lord. Here that clearly mentioned that this petitioner also has granted the bail earlier.
Anticipatory bail.
Anticipatory bail.
Then it's all right, the anticipatory bail, since you have the anticipatory bail from the beginning, FIR was under section
307 minute.
307. What is the big deal about it? Why are you agreed?
Because when offense 307 has been charged sheeted, cognizance has been taken for 307.
So you, what do you want then? Who decide?
Let it be continue till the judgment of the Supreme Court, the 2011
You need a
volume.
declaration for that. That's the judgment of the Supreme Court.
That's to unless until it not be get
Which
told.
judgment you are talking about?
The 2011 volume 1 SEC 694 millet. That is Siddharama Satilmuga versus State of Maharashtra.
I don't know. What is your challenge then?
But not but only because I even granted
Apprehension.
Yes, madam. Apprehension, but I have taken to custody because 307 is there. So my state has no jurisdiction to grant me bail case of 307. That's only apprehension.
Submits that when the FIR was under investigation, the FIR, right now, the petitioner is an accused in FIR number so under section so. When the investigation was going on, he applied for anticipatory bail before this court by filing AVPN.
No, pending with the SDM ongoing.
It will be committed now.
It will be committed in future, till that is not been committed.
It will, after cognizance, of offense is taken.
Someone has issued.
Matter would be committed to this
Court of
Sessions Court. The petitioner apprehends that the anticipatory bail granted to him by this court, the benefit of anticipatory bail granted to him by this court may not be extended after the
Cognizance is taken to 307.
after the commission of
Cognizance
is taken under section 307 IPC and committed to the Court of Session. This he relies upon the.
Not only that I have 2011 the size 2011 volume 1 SEC that the report judgment. 2011 volume 1 SEC 694.
694.
Siddharama Satilmuga versus State of Maharashtra. Yes, I give it.
I am of the considered view that the apprehension for the petitioner is unfounded because once he is enlarged on bail, once the benefit of anticipatory bail is granted to him, the same shall continue till the trial is concluded. The only thing is he needs to file appropriate bond before the court below and appears before the court when the trial is concluded. Till the trial is concluded. Yes.
But that benefit will continue till the end of the trial.
I have said that apprehension is not. Yes. Next.
24.
Can you see page 10, annexure 1? This is someone was issued by the SDGM, Jajpur, under section 110 of CRPC to execute the good behavior of bond of rupees 10,000 without complying the basic requirements which the provision says. So, your Lordship may kindly see the provision 111. 110 notice, someone was issued under section 110, your Lordship, to execute the bond. But there are no such criminal cases against the present petitioner, and the basic requirement which is lacking, that no substance of imputation has been mentioned in the summons, which is the basic requirement that should be fulfilled so far as 111 is.
Why this was issued in relation to what?
So nothing.
What have you done?
There is no such mention why it was issued, and no substance of the imputation which is mandatorily required. It has not been mentioned. Provision says and your lordship, I am relying on judgment. On that ground, it has been set aside. The substance of imputation must be mentioned in the summons while prior to.
The first paragraph, right, it's right. It appears from the police report that the delinquent is a habitual offender and involved in so many cases and also have a criminal background.
Your lordship, this
The
is not the-
delinquent is fit to be booked under 110 CRPC. And 110, you have to furnish.
Your lordship, this is not the substance of the information. The substance of
How
the.
do you know? Where is the police report?
No, sir. Your lordship, this information, substance of the information must be in writing.
What is the
summons.
police report
Lordship.
against this man?
My lord,
What is the police report against him?
there is no instruction regarding that, my lord, only the.
See instruction, what is the report? What is the report? In how many cases he involved? Nothing is written.
Oh, my lord.
All fine morning, you just give a notice under 110. You have to give details, what are the cases
Yes,
against him and something.
Yes,
What is the basis of issuing of this notice? Issue notice. To
Yes,
this
ma'am.
party, and Mr. Rahul appears for the state and seek himself. Next.
25.
Your lordship, miscase for stage they are, your lordship.
Hmm?
Stage they are miscase. I file a miscase.
What say?
Your lordship,
I
on
have-
8th, your lordship, on 8th, the petition has been directed to.
Don't
executive
go,
court.
don't go. You say that it is sub judice before this court.
Lordship, because your lordship, I am relying on one judgment.
What is judgment about it? You simply say that I'm examining the veracity of this. Go and tell. Don't go. A 110 notice, I should not have interfered at all. Only because that is vague notice, therefore I am issuing notice. 110 notice, what will happen? 10,000 bond. You don't give a 10,000
He is a
bond.
student.
You need not pay 10,000.
Yeah, habitual
Only
offender.
sign a document 10,000.
Habitual offender ହେଇଥିବ ଆଜ୍ଞା sensitive ଜିନିଷ election ହେଇଯାଏ
I
habitual
know that.
offender ହେଇଥିବ so
Election मध्ये कोण जामा तार
ଦେଖିବ
habitual offender student.
instruction ଟା ଆସୁ ବ୍ୟସ୍ତ
Can a student be, your lordship, branded as a habitual offender without any?
That is the reason. That is the reason. I wish to know.
my lord
What
I
are the
asking
matters?
that what were the cases why you were
During election time, they give this kind of notice to almost everybody in the village. Yes.
May I please, Mala? Mala, this is a matter where the present petitioner is journalist having its own repute in his locality, Mala. There was a quarrel between the wife of the present petitioner and the wife of one of his brother, Mala. Then the wife of the present petitioner went to the police station and he has lodged an FIR.
Now FIR is now registered.
No, my lord,
Investigation is on.
the FIR which the present petitioner lodged, manner that was on 14th, but it was registered on 15th. But the agreed persons, the persons which met as the opposite party number 4, he filed the FIR letter on the present petitioner, and on the same day this FIR is registered, mal. Now the police is running, opposite party number 3 is running behind the present petitioner to arrest him, mal. Only to keep in the eye the present election, mal. Because the present petitioner is a journalist, reporter, and he's published some articles in the Odia Daily newspaper against the local police, mal. This is the reason behind, mal. And the allegation is under section 34, 379, 427, 506, mal.
You are Subrat Kumar.
Yes, Makurman.
Who is Rasmita Makur?
Mala, she is the person who is registered this annexure 2, Mala.
You have not filed anything except
two
FIRs.
Yes, Mala. The FIR has registered, Mala. The false FIR has registered.
You will say false which will not make false unless you substantiate it by filing some document, something. What article you have written? Show me the article which you have written. Show the article which you have written against the police for which this FIR is alleged to have been raised.
No, that is I have not submitted. But beside whatever she has mentioned, my lord, that the present petitioner has stolen some rupees from his house.
Sir,
all these things are my lord.
Then it has to be investigated. How can I quash it at this stage?
Well, you
tell me any material.
I frame, my lord. Notice may be issued. I may be protected.
Why should I issue notice?
I may be protected, my lord.
Why?
Not to arrest, my lord.
Why?
Well, because all
You have not made out a case.
Yes,
only in the entire petition you have filed a one annexure, copy of one.
All others, my lord, all others members of the family of the, even the as old mother of the present person is called by the police, and they all from there for 42 notes.
I don't know. I don't know all these things.
telling, but nothing is there on the record.
Well, I'll submit the articles, my lord. So I may be protected, my lord, because for protection, my lord, because I'm a journalist reporter, my lord.
482 is not meant for protection.
Yes, my lord, but
Protection is somewhere else.
yes, my lord. So I pray annexure 2
You-
is a
you-
totally
you-
false, my lord.
see,
From the face it shows, my
You
lord.
may be correct.
Yes,
You
ma'am.
being a journalist,
Yes,
you
ma'am.
might
I am
have written
correct,
some
ma'am.
article for which the police might be
Yes.
chasing you.
Yes.
But you have to substantiate the case by filing all these documents.
But
Only 2-page FIR you are filing and an application you say that take.
I'll submit, my lord.
My lord, along with this
The
petition,
article will have to do the.
another
Where are the,
two
where are your
independent activities
averments?
there.
So tell me, averments.
My lord.
Averments regarding the article and all. In the petition.
Now, in the page number 6, I have made all these things, my lord.
Where
The
is
men quarrel between the two women and the ugly step only the present petitioner and the
page?
harassing as a present petitioner, being a journalist, reporter of reputed Oriental newspaper, of some of his news articles were published against the illegal association
Show
of
me,
people.
show me. Where is it?
My lord, that is
Para?
para 6, my lord, page 4.
Huh.
Page 4, para 6, my lord.
Whether
Yes.
you are journalist or no, I don't know. What article?
Well, I'll submit well everything, my lord. For the elections, my lord, because I am hiding now.
But the petitioner seeks adjournment to file the additional document to substantiate his case. Reach the matter next week's list.
Article along with the identity card of a journalist.
Whatever you want. to
Whatever
file.
I will submit everything.
Whatever you will file. Yes.
Until then, I have to be protected.
No.
Well, without
Nothing.
protection,
No. Incomplete petition, I can't believe like
well,
that.
if they'll.
The averments is vague, no document, and you
No,
want
I'll submit, if they will.
482s are not meant for protection. 438 is there, you go there.
Not to arrest.
No.
Because
Don't
once-
misuse.
No.
Please don't misuse 482.
Because once they will arrest
At
you.
least you file proper document,
Yes,
proper petition.
So in the course of the day, I will file mal. Let this matter may be taken tomorrow, mal.
You are not giving letter to the headmaster for by.
No, not like.
Like a
I'm
student,
sorry, mal.
you are writing.
I'm no.
Beg to.
No.
What
I'm
is this?
sorry, mal. Well, I protected mal.
This is
I'm
the
a
petition.
core reporter, mal, journalist, mal.
I know.
Actually, we are.
I'm so sorry. I'm so sorry, Mr. Mishra. I'm so sorry.
I'm sorry,
I
mal.
can't help you
I may
because your petition is.
Yes, well, I may be protected, mal. Until until 7 days.
Because
I'll-
you say he's a journalist,
Yes, mal.
and therefore I'm keeping it on Tuesday.
Tuesday, until then,
No, nothing.
No, I'll submit everything because the mal.
Otherwise, I'll just dismiss it.
No, I'm sorry, mal. Because
Go to police and tell.
no, well, the petitioner is now.
Don't make unreasonable prayer. Try to be fair to the court. Don't make unreasonable prayer.
All-
Yeah, this FIR is lost just few days back.
Yes.
You have filed only a FIR copy. You are making all submission under the sky without there being anything in the record.
No, I'll submit, mal.
And you want that I should believe it and say and everything.
Most protection, mal, because these persons, mal, so aggrieved. The opposite point number 3 is running to the different houses of
You
the.
may be correct, sir, but where from I'll get all this?
It is common today.
Where from I'll get?
Up to Tuesday, I have to,
This is a court of record. I
Yes,
can't
sir.
believe whatever you say.
up to Tuesday, I have to be protected. Up to Tuesday, I'll submit.
If you anything happens, Monday morning you come and mention.
I'll be protected.
You should be serious. If,
Well, I'm serious, mal.
if the threat is so apparent,
Yes.
and if he's a journalist, at least prepare the 482 petition in such a manner.
I'm sorry.
You write article published on such and such day. This is the article. What are the contents of article? Something you have to tell.
All right, in the course of the day, I will ask and you'll send. WhatsApp.
You mention
Up to Tuesday,
if-
I will be protected, mal. Otherwise, once I will be arrested, mal, I will be nowhere.
26.
26.
And you are a journalist, you know how to avoid police.
Once arrested, then I will be nowhere, mal. So,
You know how to avoid.
up to
Till
Tuesday.
today he has managed and how so many days he can manage it better.
He can manage.
No, I will be up to Tuesday.
Next.
26.
26.
May I please? A bail better, my lord.
Yes.
The bail is 3113.
When you got bail, when?
3113. Bail order.
13 bail.
NBW
24/7
17.
17. NBW. How many of you are there?
Oh,
500
10.
each. 10 people.
10. We all were villagers, my lord. Village dispute.
500 each.
300. 300 is for.
Next.
27.
5,000. Yes.
May I please, Your Honor?
Yes.
Lordship, NBW issued on 27th April 2023.
Yes.
My lord, the matter was posted for production of other accused.
You people, you are on bail or not?
Bail, my lord.
When? Give the date.
Belgium case. This is a Belgium case.
3/1/2009
3/2009 NBW
On 27th April.
500. Yes. Yes, I passed it. Yes.
28.
May I please, my lord?
Yes.
My lord, NBW was issued on 18/4/2023, my lord. Page 11, my lord.
Bail.
Earlier bail, my lord.
On bail. They are on bail. Auto charge is at 500. Yes.
Obliged, my lord.
29.
Yes.
May I please, your lordship? Lordship, this is a Belgium matter. NBW was issued on 15/7/2011. Petitioner released on bail on 31/5/2001.
31/5/2001 bail. NBW 11, sorry, 15/7/2011. 2011 NBW. Now you are coming.
Lordship.
1000. Yes.
30.
Yes.
My lord, NBW issue against the petitioner on 12/4/2022.
Yes.
And the petitioner is alleged under section 341, 323, 379.
Tell me the bail. Don't
Yes,
tell-
my lord.
When you got the bail?
Bail is not understood, my lord.
On bail. Before 12/4/2022, 500.
31.
500 each, huh? Yes.
It's a Belgium matter. NBW was issued on 9/1/2018. He was on bail on 25/11/2009.
25/11/2018. 9/1/2018, huh? 1000. Yes.
Obliged.
Yes.
32.
To my lord, Belgium matter, NBW was issued on 16/2/2024 and bail granted on 21/10/2022.
22.
Well,
Yes. Noted down. 500.
obliged.
Yes.
33.
Please, lords.
Yes.
My lord, Belgium matter. And NBW is in January 20, 2023.
10th
January 20, 2023.
January 20, 2023.
Yes, madam.
NBW.
Yes, madam.
Bail.
And petitioner had a police bail on for deduction of this honorable.
Bail. What have you written in the prayer? That is
My lord, was the NBW one.
10/4/2023 is the NBW.
My lord, item number 36 also same case.
I'm talking about 33.
Yes, my lord.
NBW was issued on 10th April 2023.
Again.
10th April 2023. Yeah. 500. Yes.
34.
My lord, item number 36 also.
1 minute. 36. So when
34, my lord. NBW 13/12/22.
Yes.
Page 11, my lord. On repeated call, neither the accused nor PP is nor agent.
13/12/2022 NBW. Bail. They were on bail, I'll write.
24th July 2019.
Sorry? Acha, you are repeating. Yes.
My lord, bail on 24th July 2019.
29. July 29. NBW on
30th December.
13 bar wise.
ठीक है. 500. Yes.
35.
Yes.
May I please, your lordship? My lord, this is a Belgium matter.
Yes.
The present petitioner was on bail on from 30/9/2022. NBW issued against the present petitioner on 22/3/2024.
500. Yes.
36.
Obliged, your lordship.
Yes.
My lord, same GR 403/12.
Same. 240.
And date difference, my lord.
They, nahi, 10,
Yes,
10/4/2023. NBW. Nahi. What? She's writing something else in the prayer, something else in the annexure.
There is two
Which is
orders.
correct?
My lord, there is
48
two
days
orders.
election.
One is 10 April and one is 20 January
In the
2020.
prayer you are writing 20th January 2023.
23.
Annexure you are filing something. Write down 20th January 2023. NBW. They were on bail. 500. Right. Yes.
37.
Lordship, this is a Belgium matter. Petitioner was earlier on bail, Lordship. And NBW was issued on 1st November 2023, Lordship.
23.
Lordship.
500.
Obliged.
38.
May I please, my lord?
Yes.
My lord, case of Belgium,
Yes.
The petitioner was earlier on police bail on dated 22/7/2020
Hmm.
and NBW issued on dated 26/2/24.
500.
Obliged.
39.
May I please, your lordship?
Yes.
Belgium matter, your lordship.
Hmm.
The earlier, the petition was bailed on 17/3/2016. And NBW has.
17/3/2016.
16.
16. NBW on 8/2/2023.
No, 4/12/2023.
4/12.
2023.
23. Okay, 500.
Deep loveless.
40.
May I please? My lord, case of Belgium. Here, my lord, the petitioner was earlier arrested and released on bail on dated 27/2/2017 by the learned trial court. I have taken a specific averment on para
Yes,
4
and
thereafter NBW issued on dated
27/2/24.
27/2/24.
500. Yes.
Obliged.
Yes.
41.
41. May I please, my lords? My lord, I have filed an IA in respect of order passed on dated 18/8/2023, my lord. That may be,
What IA?
my lord, IA for my lord, change in the prayer and other portion of the. In the meantime, my lord, charge has been framed in the present case. So, my lord, I filed the IA as per the order dated 18/8/2023 by this.
Yes.
Yes, my lord.
Charge has been framed.
My lord.
Then you have filed revision.
My lord.
Criminal revision. You have
My-
filed a criminal revision. Criminal revisions.
My lord, prayer portion may be modified. For that reason, I have filed an IA 594 of 2023.
What do you want? 590?
Page 18, my lord, lordship.
Yes, my
permits,
lord.
my lord. At page 18, my lord.
If IA is
Washment and order by which the discharge application was rejected, my lords. Now, in the meantime, my lord, charge has been framed.
You're right.
We want to incorporate that by an amendment.
Yes, my lord.
But he has filed an application for modification.
My lord, if this prayer is allowed, I will file an amendment, my lord.
The prayer, you are
Prayer for-
allow the modification of the prayer as in the grounds. The petition for but the criminal revisions are not there.
My lord.
Yes, yes.
Vigilance matter, my lord.
Application allowed.
Obliged.
In terms of this content of in terms of the demanded.
Obliged, my lord.
Yes. Next.
42.
Yes. Yes.
42.
42. None appears in the interest of justice.
43.
May I please?
Yes.
In this case, I have filed an interim application, IA number 625 of 24.
Yes.
It has not come to the list, my lord. And
620.
625.
Yes, it is there. What do you want?
In that, I have paid for extension of interim order, my lord.
Which interim order?
Interim order of stay was passed by this honorable court.
24/1/23.
My lord.
Yes.
But this matter is regarding a matrimonial dispute, my lord. It has been ended with compromise. And mutual divorce has already been passed. And all the articles and permanent alimony has already been given to the opposite party to wife. At that point of time, since the brother of the OP2 is a lawyer, friend of mine, assured me, you file an application, I will appear and will dispose it of. But in spite of notice and everything has been completed, she is not appearing before this honorable
So
court.
what do you want now?
So let me take further notice
Written, my lord.
through
Not written.
No.
Notice issued, my lord, but not.
AD
written.
not written, but track report has not been filed by the office.
All right.
Now,
Then simply adjourn it.
My lord, it was filed, notice was gone in the long back 2022.
Awaiting service on opposite party number 2, adjourn to.
Yeah, I pray, my lord, let me allow me to take notice on special messenger, my lord. Requisite by Friday.
Ready? And release the matter.
And interim order will be.
Interim order to continue.
My lord. Okay.
Yes.
45.
Yes.
I prefer one adjournment, my lord. Let it come
Adjourn.
next week, my lord.
46.
Next week. Let it come next week, my lord.
You don't decide.
No, my lord.
You don't decide. You sought for adjournment, I granted. Then the office will decide. Okay.
I beg pardon, my lords. In item number 41, my lords, my learned friend appears for the petitioner. I am for the state vigilance, my lords. Now, my learned friend has prayed for the amendment of that particular prayer, incorporating the date by which the charge has been framed, my lords. The lordship allowed it, my lords. But let my learned friend say incorporate the date when the charge has been.
My lord,
Order dated so and so when the charge has been.
It is his petition. Is incomplete prayer, I'll dismiss it.
No,
let him do
my lord-
whatever he wants to do.
That date was not there. That's what he's.
my lord, may I have a glance to the last orders, my lord.
Neither you can advise nor I. Let him do. It is his petition.
My lord, may I have a glance to last two orders, my
No,
lord.
I am not going.
My lord,
You
my lord.
want to amend your petition, you do whatever.
My lord,
If the incomplete petition, then he'll take objection and dismiss it.
my lord, my lord.
As simple as that.
Yes. Oblige,
Do
my
it
lord.
according to your,
My lord.
Now, entire his grievance is paid with the quashment of that particular order framing charge, my lords. But when the charge was spent, the order date is not mentioned in the prayer.
then you take that objection. Then we'll on that ground only we'll
Dismiss, my
see
lord.
that it can be.
Let him mention the date. Data goes on.
And he is only advising you.
My lord,
He is senior,
I'll obtain instruction, my
take the
lord.
plea and do it.
My lord, I'll
Take
oblige,
it as an advice.
my lord, I'll
Okay.
take it.
Okay.
Oblige, my lord.
46. Yes.
Urgent.
Non-appears. Intercept receipt.
47.
47, your lordship, three defects are there.
Want to cure?
I will remove that.
Petitioner seeks time to cure the defects pointed out by the registry. Please the match. Yes, next.
48.
None appears. We need the subject.
49.
Yes. None appears in the intercept.
50.
Three models are there. No. Now appears the intercept schedule. Don't give longer data on these matters. Or take second week. Yes.
Already after vaccine, filled up.
Would it come to what? Yes.
52.
Yes.
Petitioner.
Are you changing in the display board? Huh?
I'm changing.
52 मतलब कॉपी नोट साहब 52 कॉपी दे दीजिए ना देना तो अपन ऑफिस तो लिखे दीजिए अपन जब देख जब देखा जब देखा रिसीव देखा
Where
Government
show me
receipt.
display board. Show me the display. Where is our 52? Okay. Yes. Yes, yes.
Petitioner is challenging the order dated 25/7/2023 for not releasing the accounts which has been freezed by the IO, my lord. So, my lord, the case is that, my lord, the petitioner has sold some land to the my lord, OP number 2, my lord. Home Aragya Hospital, and subsequently alleged that
Your account has been freezed.
account and that was rejected at the time of during investigation. Now we have sent to custody for 6 months, and investigation has been completed. And because they have not completed the investigation for so many days, I have filed CRLMP petition.
Yes, Mr. Rahul.
Yes, my lord, this-
Copy just.
And in the CRLM petition, it has been, they have said that we have completed the investigation and submitted the charge sheet. So for that reason, that was rejected on the ground that the page 100 dispose of the because the investigation is still pending. Now investigation.
His accounts were freezed.
Yes, my lord.
He moved the application before this court earlier, and the trial court rejected his application at the stage of investigation, saying that since investigation is going on, so there is no question of release.
Yes, madam.
And now charge sheet is filed, and he came to this court. This court says that wait till the charge sheet is filed.
Yes, ma'am.
Now charge sheet is filed.
Charge
What is
sheet
your
is-
response?
My lord, I'm sorry to say that your lordship, whatever may be, passed. But in the item number 52, my lord, there is an instruction from my office. There is no copy not served, my lord.
Give us a copy.
Why a copy? Kindly give a
Inputs of the
copy.
day I will.
I'm just issuing notice, you should serve the copy.
Yes,
Issue notice.
yes, madam.
Serve the
Copy दे दो तो sir.
Yes, madam, I'll-
Sir notice करो.
Issue notice and give the copy. ठीक है.
Pardon, my lord, 49 item.
Yes, I saw you running.
No, no, yes, sir.
Tell me what.
I have filed
I've just-
IA for releasing those matters. Releasing.
That would be tantamount to allowing the main prayer. Wait, I'll decide whether, how can there be an interim order?
Because account.
There can't be an interim order. Interim order is tantamount to allowing the main petition. I just issue notice on both. Yes. 49 I have urgent.
49.
I urgent it because today it may not be possible.
Short date.
I have just urgent it.
Yes, sir.
He'll give a short date. If there is very urgency.
Yes, madam, yes, madam.
Then next week, just. Yes. 53.
My lord.
It may not be possible therefore.
Non appearance.
Non appears 14 se cut dabo.
49.
49.
53, my lord.
Hmm.
I have filed that CLMC for quashing of the criminal proceeding on the ground of compromise, my lord.
Where are they? What is the offense?
Offense.
323, 324,
Yes, where are they?
379.
Yes, where are they? You bring them.
My lord, sir, not today. That next date may be fixed. Date.
Fix karo.
Huh? Copy दिया है इसका?
54, but all are illness. And my lord has directed the concerned district authority to make it settled, my lord. And report has also been called for. Report has not come as per the noting, my lord.
Last order.
Last order 21/3/2024.
Mediation. I'm waiting the report. Of the mediation cell of Nuapada. Urgent.
Interim order.
Interim order to continue.
55.
My lord, petition challenging the order dated 5/8/2023 passed in GR case number 348.
Yes, tell me what you want.
205 petition is rejected, my lord, after issuance of NBW. The petition is a poor person is working outside of state, my lord. I pray for.
In the petition you have written you are from Pipili Puri.
My lord. Outside काम करते outside.
What are the offences?
All the offences are available except 307 after charge sheet, my lord. 307, 379,
307, my lord. Charge sheet is submitted showing them absconder, my lord. Cognizance taken, my lord.
Now 205 is moved.
Not my.
Similar, Honorable High Court also similar case or.
Absconder thale.
Absconder thale.
307. 307.
Similar after charge sheet.
No.
Just PK Mishra. Similar.
Session tribal na. 205 आला session tribal अपन से बन जीवे एमती lawyers application गोटे कोटे लाभो सेटा जिया पड़े पुनी
अन्यमान सब पढेलेनी
काना community पठाओ
NBW issued.
Well,
absconder
I will set aside the NBW code appear and move appropriate application.
that much he want.
Where is that order?
well,
Where is that order?
order dated by lord at page number 36, my lord.
Page 36.
My lord, 5/8/2023.
Page 36, na?
My lord, page.
Okay.
37 page third page 37 madam. 37 aram 37.
Petitioners are accused. How many of you are there?
2 persons.
2 persons. 2
Petitioners are accused in FIR number so. Charge sheet was filed by the police in this case, showing the petitioners the absconder.
Absconder.
The petitioners moved application under 205 CRPC before the court below. While order dated 5/8/2023, the said application was rejected and NBW has been issued against them. The petitioner is agreed by the said order and filed the present petition. I am not inclined to interpret this matter. However, the petitions are directed to appear before the court on or before 30th of May 2024 and file appropriate application seeking appropriate application as per law. Till then, the execution of NBW issued against the petitioners under order dated 5/8/2023 is a state. Yes. 56.
Your Lordship, Mr. S.S. Das is held up in another court. May I request for a passover, please?
Today it may not be possible.
Indeed, the matter has been posted to 25 2020.
Which one?
This matter. I am for the
Your-
appearing instructed to appear on behalf of the complainant. So copy may be served. Let the all the matter has been posted to 2025
Before trial court.
Your Lordship,
before this another court.
Mention it has been mentioned, my lord.
It has-
Your Lordship,
I accept by the petitioner, my lord, for that.
But the matter has been posted
mentioned.
25.
Lordship, if I am
Your
allowed
Lordship.
for 2 minutes, I'll just brief your Lordship
No, no.
on why we have filed
Tell
this.
me.
Your Lordship, we have actually filed two modification applications, modification of order dated 22nd of March. Your Lordship had granted interim stay to continue, however, it has not reflected in the order. There are, which is why we have filed two modification applications.
The copy maybe I am appearing for the complainant. The copy may also be served. Instructed to appear.
Where you filing vocal or no?
No, I will file my lord. A copy maybe sir. I will file.
So,
In one case, I have appeared.
there are all the matters are coming up 20th May.
Yes,
My
my
lord.
Your Lordship, all of them will be posted on 20th May only, just that interim order to kindly reflect in the order. It didn't reflect in the
Earlier
last
interim order
order.
was there.
Yes, Your Lordship. Interim order was.
Earlier interim order was there.
My lord.
Yes, Your Lordship. So in all the three, interim order may
Right.
kindly continue and the same may be
And the
reflected in
copy
the
also
order.
may be served.
Don't go until appearance of the opposite party number two. Opposite party number two. The matters are already listed on Kudiya Panch 2003. The petitioners have moved an application in the application inter India praying that the interim order earlier passed by this court was directed to be continued. However, in the order sheet, the same is not reflecting. The application is allowed the interim order to continue till next date of hearing.
In all the three matters, Your Lordship.
And copy of the two.
Copy,
A
the
copy.
petitioner is directed to file copy, furnish the copies of the petition to
Copy number 2, my lord. Complainant. My lord.
Will do, Your Lordship. Obliged, Your Lordship.
all the three matters, huh?
Yes, Your Lordship.
57.
57. May I please? My lord, on the last occasion, this honorable court directed the opposite party to issue notice to the opposite party number 3, and the noting is showing that the item is delivered and confirmed.
Which is party number?
OP number 3.
Just see, service.
It is not written.
So awaiting the service on respondent of the urgent. Okay. Yes.
58.
Pardon, my lord. My lord, item number 49, interim order continue, my lord. Adjournment. My lord.
Wherever there is interim order, it will continue. Yes.
58, my lord, but only GR case number 119 of 18 that should be, but in that place that is in 18, keeping in view the prayer and also the annexure 2,
Sorry.
that so far as the GR case number 119 by 19 is 2019, that should be 2018. Prayer of the petition was 2018.
Who is written that?
GR case number 219 of 2018 that should be.
Correct. Nami, 200 GR case number
199.
in the order dated 19/3/2024. The GR case is wrong to mention.
Much obliged.
199 of 2018 होगा 19 लिखा है.
Right.
Correct.
Much obliged.
Item 59.
2018 होगा था 19 लिखा है.
May I plead? One noting is there, my lord, a typographic error, my lord. That's why I will correction, my lord, giving.
Yes. The land counsel for the petitioner seeks time to cure the defect pointed out for the registry. Please the matter. Yes. Oh, that's
60. 60 somebody else. 60 time out.
60.
Time out.
Somebody asked for time.
My lord, then interim order to continue.
61.
on appeal in the interest of justice.
62.
That's last occasion, the petition number 1 and OP were present in this honorable court, my lord. The lordship dispensed with the appearance of the OP number 2, wife,
Yes.
and directed for presence of petitioners. Out of petition 1 and 3 present. 2 टाको contact ही पाइलानी से out of village अच्छी पढ़ेजी बाहर बोल से मान को उसने contact करी पाऊँ ना.
ताले कौन कोई? Simply urgent. May first week, second week urgent.
Anchor personal appearance may be dispensed with, my lord. Personal appearance petition number 1 and petition number 3 may be dispensed with.
No, these are settlement matters.
Settlement.
Let them come second week of May. Yes.
63.
I mean, pardon me, item 61, my lord. 54 wrongly. The board was giving the wrong. Right. They are the husband and wife dispute. The wife is not turning up, my lord. May I pray, my lord, let it be sent to mediation cell so that it can be settled.
FIR under section.
490. Husband and wife, 2 children are there, and they have also the petitioner has also filed application for guardianship act. All these things are disputed, and it can be sorted out. The husband is also ready to accept the wife. And about 10
You have filed for quashing.
Yes, husband has filed.
Notice was issued, but
It's
not served.
No, it has been issued, and she is not turning up. The mediation cell can take care of all such things, and it can be split up.
What do you think? You are appealing.
No. For the petition.
61.
61.
Okay.
It can be sorted out. That is
The petitioner, who are the petitioners?
husband, yeah.
In-laws.
No, husband.
Husband and other.
Husband and other in-laws, madam.
In-laws of husband or other?
And other.
Petitioners are the in-laws and the husband of opposite party number 2.
True, madam.
At the instance of opposite party number 2, FIR number 2 was raised. This court had issued notice to opposite party number 2 wide order dated 2/3/2020.
Don't, madam.
Despite notice, nobody appears for the opposite party number 2. Since this matter is arising out of a matrimonial discord, there is all probability that matter would be settled. Settled. Therefore, Mr. Chand, the responsible petitioners, submits that the matter may be referred to mediation. Mediation. Let the matter be placed before the High Court mediation cell, and coordinator of the High Court mediation cell shall issue notice to the parties, fixing a date and explore the possibility of settlement, awaiting the mediation report adjourned to.
Till that period, or interim order continue? It was earlier there.
Interim order.
Yes.
Pardon your lordship, item 50 also similarly, because of the board lag, it has been.
50 pass over after.
Yes.
Item 42 will pass over. Item 42 will pass over.
I've adjourned and nobody was there. What to do? Today it may not be possible.
No, as soon as week or after week.
If there is no pressing urgency, then it can be,
63 may lords may kindly adjourn it. Any date first week of May.
Adjourn.
42 after week. 50,
64.
Grateful.
64, if an adjournment notice was issued, and here there is a dispute, boundary dispute. Your lordship directed for settlement of the matter. So I have instructed, so an adjournment may be given, is notice of the boundary dispute. 0.2 decimal, I have a ice factory. They are saying that I have enclosed some portion of boundary wall. So that's why cognizance has been taken for
Adjourn on request, interim order to continue.
Obliged.
Yes.
65. 65, pray for passover, madam.
Passover.
66.
63. Yes.
Well, here, it's basically a dispute between two cousins. The present petitioner was looking after the father of the informant. And my lords, he had purchased some, he had sold some lands, which the money is with the father, my lords. Thereafter he has died. It's with the informant. Now, my lords, the dispute revolves around 7,52,000, which the informant says he has clandestinely withdrawn. I am ready and willing to give back this amount. I've already deposited it, this amount in court in pursuance of your lordships.
That is 7,54,000.
54,000 and I've already deposited it. And I'm willing to give it back to me. I don't want a criminal to face a criminal case, my lords. His father in good faith had given it to
You are
me.
appealing for.
I am
He
appealing.
has deposited.
I will obtain instruction. Oh, actually.
Take the money and finish, sir. Why unnecessary?
No, whether the amount is that or not, I will.
It is
That
as
is
per
what
the
I assured one thing. I assured the honorable court, if my friend wants, release that money in favor, and if he will comply that amount, I will concede to quash the criminal proceeding. No.
Now, if he is not conceding to quashing of this thing, it cannot be released. If he will take this money and concede, then we'll.
Oh, okay. To that extent, I.
Yes.
But I require instruction, otherwise.
Monday. You come and tell. Come and tell if he will take this much amount.
Yes, yes.
And,
Yes, I will
we'll
obtain
quash it.
without the instruction of the
No,
party, I
obviously,
cannot
obviously,
concede.
obviously.
Certainly.
Monday. Tuesday.
Tuesday.
Let it be Tuesday.
Interim order by
Interim order. Tuesday, you please
Yes,
advise your client, take the money and.
I am not interested, he will face the music of the criminal proceeding. Yeah. I am interested to get back my money.
Because the music is not rhythmic, that is the reason. He doesn't want.
A very drastic music. Man.
Music not soothing. Not soothing also.
Yeah. 69.
This case, my lord, quashing of order of cognizance, my lord.
Yes.
The opposite party initiated a complaint case alleging
Yes, notice has been issued.
notice issued,
Who is
interim
appearing
stay
from
granted. Last occasion, my lord, during the course of hearing, your lordship wanted to see the initial statement and the
Yes.
202 inquiry. I have brought the certified copy. The counter is narrated a cock and ball story. Nothing is available on record. And this is the certified copy. A new story has been argued last occasion. That's why your lordship asked me to produce the initial statement and the.
If on the basis of
Inquiry.
initial statement
Nothing-
and
nothing
complaint,
amended.
if prima facie case is made out, cognizance is correct.
My lord, that is one part. Secondly, my lord.
No, that is the only thing.
Yes.
You show me.
One witness examined who was also a director. It is a 138 NI Act.
You are the accused.
No, he is accused. Opposite party is accused in a NI Act case initiated by the present petitioner at Delhi. The moment he received the notice, his prestige lowered down. When it is circulated in his locality, his goodwill lost, everything.
Oh,
lost.
that is 500.
500.
Oh.
For that case.
Oh.
My lord, the 138,
I
if
recall.
the person committed
Yes.
an offense on
Maybe because the 138 case is filed against you, you are deformed. So therefore, you file a 500 petition and say that cognizance should be taken and cognizance is taken. On that ground, how can it be?
Millards, on the last occasion.
He has a legal right to prosecute you. You have issued a check. Here filed in Delhi. And your entire allegation in the complaint is, since you have, he has prosecuted you under 138.
I have
So therefore,
received
you
like
are
the
defamed.
Millards, on the
And
last
private.
occasion, Millards directed the Learned Standing Council to assist us. Millards, actually, Mr. Maharaj is not present today and he has asked for adjournment.
Mr. Ragda is there.
No. Nothing is required, my lord. It is a complaint case. I have produced the certified copy.
I'll tell you what had happened. A check was issued by her client.
Director, managing director of a company.
Security check, Millards.
Whatever
Whatever it may-
a check was issued. The check was deposited check was issued in favor of his client. The check was deposited, it was dishonored. And after dishonored, his client prosecuted her client in the 138 proceeding before Delhi. Once that complaint was filed, then her client files a complaint here in Bhubaneswar saying that I am defamed under section and 500 cognizance is taken on the ground that you have prosecuted me in that 138 case. What is defame about it? He has a legal right. You should be check, right, wrong, whatever. He is prosecuting you. What is defame about it?
That is no illegal. That can.
I'll quash it.
I think this is also covered by a Supreme Court judgment last.
What sex, sir? I'll quash it. No defamation under section 500.
That's it. Only
And if you are acquitted, eventually if you are acquitted, you can file a suit for malicious prosecution.
She is ready, but in presence, if he disposable in presence of her senior man, senior counsel.
Genuine.
Millets next week, Millets week.
Monday.
I will not available.
Monday.
Millets Monday.
My daughter's marriage is fixed to 26th April. I am not available this month. Because your lordship wants to, if he wants to take adjournment, no, with lot of pain today I was present because I have committed to
You
remain.
tell
present.
me the date, whenever you see.
But in the month of May, first week or second
First week, May, na?
6th.
No. First May.
No, I have no objection.
First May. Let it be first May. We'll pass it. Nothing is there.
First day, my lord,
First May. Second May.
Millets second. Millets.
first May, I have no objection. If it is not a holiday. then-
Not holiday.
No, I have no. Yes, my lord, first.
Labor Day for that is.
First May, I am ready. ma'am. I am ready.
Millets on first May, there is another matter outside Millets. So Millets, my senior won't be present, so.
Okay,
The
second,
second.
let it be second. Again, first May, he'll ask for adjournment.
Let it be third May, my lord. It is
Okay,
second.
third May. Okay.
Okay, great.
Okay, third.
Interim order to continue.
But tell your senior that I am quashing it. Interim order to continue. No 500. What defame? Yes.
70.
Whether this is the matter, Lordship, in fact, observed, that is not reflected in the order. Lordship, the issue was taking cognizance on the FIR, developed. So that was the issue. And Lordship wanted all the disputes pending between the parties, the divorce case, as well as the DV case, domestic violence case, and another case, something like this FIR part. So these three, Lordship wanted all the compilation, I filed it. Now the question is, Lordship, last date observed, that let the parties come, I will make a sitting up. And I called my client, he has come all the way from Sweden, and he is having holiday up to 18th only. So today is the date. So there is none from the other side.
Mr. Malora, Rajit Rai.
Mr. Rajit Rai. In fact, I had a talk to him over phone. He said, I'll be there.
I'll pass it over.
Okay. Pass it over. Lordship, my request is, if Lordship can have it in the chamber as you discussed the last date. So if the party comes, can it be possible, Lordship, to have
We'll
it?
have it in chamber, 3 o'clock.
So that it will be, let there be a negotiation and whatever Lordship will propose in presence of the parties and
3
all.
o'clock in chamber.
So there is no issue between the party. There is a divorce case and divorce is withdrawn.
They can't pull on together. Why unnecessary?
Lordship, the society is in a different way. So we are all victim to this.
Yes, your client is staying in Sweden.
She is Sweden, she is here. So they
And money is not an issue because both of them are well off.
well up and both of them are educated and she was earning. Now, because there in the DV, there is a, payment of some 25,000, 30,000 has been fixed and all that. So now she is not showing whether she is engaged or not. But she is qualified. She was working earlier. Now the record we don't have.
Your client should be ready to pay some alimony and.
Yes, sir, Lordship, that would be according to this.
Let us interact with them.
So that let that be one. The only technical question may arise, Lordship. What we challenged before, my lord, is 482. Now the matrimonial matter, Lordship wanted to have that can be. You can make an observation in that. Subject to the petition filed before the concern.
13(1)(b) and all. That modality will work.
Because again, a technical question will arise whether this court is assigned with the matter of.
No, that I can't do.
So that is the reason.
Pass this criminal prosecution.
So that is to be taken care.
If at all there is a settlement, we'll record that settlement to bound the party.
Right. So that's the I requested the man because Lordship observed that the party's presence.
Yes.
So he flew from Sweden.
Save them from this,
Right.
ordeal of
Right.
preaching. Okay. 3 o'clock.
So
in chamber.
3 o'clock.
71.
I have challenged the,
And for the
So this
opposite
is-
pattern. For
my lord, annexure 1,
Yes.
page 9 is the petition under section 147 CRPC.
Yes.
filed by Rizana Begum,
138.
No,
147 share piece.
Okay.
147 share piece. Between Rejam Begum versus Mahajan Bib Khatun. I am the Mahajan Bhatun, but here the petitioner. There is opposite part, second part. My lord, I challenge the initiation of the 100% proceeding as per running page 14 in this annexure, running page 14, because her husband, Rajam Begum husband, Abdul Y.
What is your case, you tell me?
My lord, the between the party, there was a partition between the they both are two brothers gifted property through Habanama from their mother, and they are living separately by making construction over the shoot land. The husband of the petitioner there lodged a FIR and also one particular proceeding before the ADC Cuttack, and subsequently the matter went to the revisional court, and the revisional court dissolved his prayer. Thereafter, he has filed in a civil court the civil proceeding. The civil proceeding is going on between the parties. In the meantime, her wife initiated the proceeding under this proceeding under 147 CRPC. My humble prayer is the proceeding is going on since 2022. Now, nothing. At a civil suit chalsi, injunction order helani, revision ta swami kartala, revision ta city tankar jahala the etu galani. Toda am coach.
My lord, the fact is that there is a common ancestral property, my lord. And ancestral property is around 0.016 decimal, which 0.07 gifted to each son, and the petitioner, her husband was died, and the thing is that there is a common passage, my lord. 0.07, 0.0 has been gifted, and left that the 0.02 decimal which is left for common passage, where the say opposite party is living, her constructed her house the western side, and the petitioner was constructed house in the eastern side, where the eastern but their threshold is for the main road, but the 0.02 which is decimal has been left. It is the only ingress and egress to the house of the opposite party house. But since it is observed that the opposite party, the second party, which is I'm reading the criminal miscase number order sheet of 14, order sheet of 104 2022, page number 14. That your lordship may see the first party got western side of the shoot land, whereas the second party got eastern side abutting to the public passage. As there is no direct passage to the land of the first party, a passage measuring 3 feet into 13 feet left for the first party to ingress and egress.
Everything is all right, but why that 147?
My lord, a date has been fixed there, which is the matter is ours to final disposal. Since the order of this, since the status quo order has when it was fixed to 18th, my lord. It has fixed to 18th. Yeah.
The opposite party states that the proceeding before the court below initiated by her client under section 147 CRPC is fixed for final disposal on 18th
of this month.
18th of April. So reach the matter after 8. Yes, let us see what is the outcome. Yes.
Well, since the order is the matter is ours to get the order of the status quo. Since it has not been obtained.
No, let us wait.
Yes, ma'am.
Only the extra disposal I read. Extra disposal is
he is saying that the matter is fixed on 18th. Let us see.
Your lordship may fix this matter next week.
After 18th.
My lord.
Yes, next.
72.
Item 72, let's kindly be taken over after first week of May.
Don't decide the date, urgent. Yes.
73.
On behalf of SP Das, my lord. One after, my lord, urgent.
74.
appear in the interest of this Belgium.
75. Yes.
Display.
Madam.
Yes, 75.
Mr. Ponda is trying to log in. Mr. D. Ponda will conduct the case. Waiting.
Yes, the folder. Is there any problem? Jyoti, is there any problem? Why these people are not able to come, join?
We are already in the waiting room.
He's already in waiting.
Some problem on their side. He's already into waiting.
Must be from their side.
Their side.
But
Let the matter be taken on Monday. I need to log in.
Mobile.
mobile is also
Mobile.
mobile is
Mobile.
that is problem.
Urgent. Yes.
76.
Okay.
Yes.
76.
Hearing matters or after lunch what did you cash in?
Possible.
All criminal revision matters. From
Criminal
76
revision, huh?
All division.
from 76 onwards.
All divisions.
Sir sitting there, well, 83 at home.
83. 1 minute. Apno kuda hearing.
Hearing.
Are you
All
ready?
matters are hearing. All the matters are hearing matters.
Which item? 83. Are you ready?
Sorry.
Tell me if anything can be done.
Only 100 rupees fine.
83. What is the offense?
1,000 rupees.
353.
353.
I guess.
Connected by both the courts.
My lord.
Yes, sir. What do you have?
Initially, charge was framed on section. The court disbelieved two offences, that is 294, 506 of the Indian Penal Code.
Yes.
On the ground that there is apparent discrepancy in the evidence of the official witnesses. So far, 353 is concerned, the court also noted the similar discrepancy therein. There is no consistency between the witnesses' place of occurrence, time of occurrence, and the document.
Right.
But in spite of that, the court convicted, trial court convicted, awarded substantive sentence.
How much?
That is SI and subsequently SI for 1 year. Subsequently, the appeal was preferred and the appellate court though confirmed the conviction, but
Only
altered the sentence part and 1,000 was imposed.
353.
Yeah.
Yes.
Even if on two grounds I am challenging the finding of the both the courts, that apart from the discrepancy appearing on the four witnesses who are the official witnesses, it is said that just I am bringing my lord's kind attention to the factual aspect. It is said that the excise personals, they arrested the father of the present petition and he was brought to the court and 4 constables were deputed and the father was in the custody of one of the person. The petitioner appeared there, abused one of the constable who was not holding the father in his custody. Thereafter threatened, and it is said that he pushed him, he fell down. That is the allegation. And that allegation, to substantiate that allegation, 4 witnesses were examined who are supposed to the excise constables.
Right.
And on bare reading of their evidence, no sane man will believe that such a incident took place. This is one aspect so far, and that was noted down by the appellate court, but still maintained the conviction. Thereafter, even if accepting the case on its face, sorry. Whether it will come within the ambit of section 353 or not. At that time, admittedly, he was not discharging the duty, and that was not prevented. The duty must be prevented while exercising the public duty. Suppose a person is standing, let us say, not doing anything, any official work, but at that time, he was on duty. How it was prevented to perform the public duty? And first witness, just I am placing the few lines from the evidence of the witnesses.
CW1.
My lord. This witness has stated that the occurrence took place in the court of SDGM, Sadar Kotak. And the time of occurrence is at 1 p.m.
Right.
This evidence was contacted by all the three witnesses. That is first point, your lordship may note it. The two personals of the court, that is PW 2 and 3, they are perhaps at that time they were attached to that court. They were examined, they denied anything, they were even not declared hostile. That means in the court itself or in the premises of the court, any such incident took place, there is no material save and except the four constables. And so far the other witness...
How much you have undergone?
No, 1,000 fine has been imposed.
You have not undergone.
Only fine. It is not that...
During trials, Honorable Court wants to know during trial court whether they have taken to consider.
No, not got immediately bail. Got bail immediately. Immediately after occurrence.
Perhaps, unless I go through the LCR, I cannot ensure.
I am just wondering if you have undergone some sentence, then
that will be set up.
No,
set up.
See, incident of 97. See, the long and short of the matter is the incident of 97. The evidence of all the witnesses are disbelief insofar as 506 194 is concerned. But in
same self-evidence
353 conviction is maintained by both the courts.
In fact, my lord, paragraph 11, my lord, read out.
It is 11 of appellate.
Trial court judgment, my lord. It is consistent evidence of the evidence of the witnesses that 10/4/1997, Radhu Behra was forwarded to the court of JBFC Rural Cuttack and accused pushed Pedal 4. He fell down. The command certificate, Exhibit 2, lends support to the claim of Pedal 1, 4, 5, and 6 that they are interested to forward the Radhu Behra as per the direction of the excise inspector, district mobile in PR number 1 of 97-98. So they were in official duty, and the aforesaid witnesses are also public servant, which with the meaning of section 21 of the IPC. It is also not challenged by the defense that the aforesaid witnesses are not public servant. It is also evident of the witnesses that the accused Kailash Behra is the son of Radhu Behra, who was forwarded to the court by PR number 1 of 97-98, and he dealt push blow to the informant, for which the informant fell down. So that act of the accused amounts to deter the public servant in discharge of the official duty. There, my lord.
That was the finding of the trial court. Reverse finding is the appellate court. Appellate court narrated how the discrepancy is there, but still affirmed the sentence.
No, come to para 11 of appellate court.
Appellate court, my lord, that is there.
Para 11 of appellate court.
Sir, also the arguing counsel in the appellate court.
I know. Come to this. No, not para. No. Para
11.
Para 10.
No, para 10 third aram kole jana apne.
No, 10.
10
Now coming to the offense under 353.
Now coming to the
that,
offense.
with regard to the production of the accused, Also there is discrepancies. It starts with discrepancy. Yes.
Court has brought out a third case and explained the things. The witness might not have properly identified which court is the SDGM court, which is the JMFC court. And the victim in this case, my lord, PW2 has stated that the occurrence took place in presence of the presiding officer and staff inside the courtroom. All other witnesses, they have stated that the occurrence took place outside the court. And if in presence of the presiding officer any sort of action, immediately it is the court to take cognizance of the matter and proceed. That is the evidence of PW2.
The incident, as per prosecution, incident had taken place in the court premises.
Court premises.
Not
Yes.
in the court. Had it been in the court might have taken
But the
suo motu or whatever.
victim to whom I gave the push, he said that the entire incident took place inside the courtroom in presence of the presiding officer.
PW2 was a constable.
PW2 3 से hostile ହେଇଛନ୍ତି, PW4 ବୋଧେ ହଉଛି ସେ informant. Your lordship, I have
PW5 is the constable has deposed.
no, PW4 ହଉଛି the informant.
He says in the veranda of JMFC court.
ସେ ବାରଣ୍ଡାକୁ ଆସିଲା ସେଠାରେ PW5 ବୋଧେ ପର୍ଯ୍ୟନ୍ତ.
That exhibit shows the committed certificate to mark the prosecution is not in conformity with the claim of the witnesses. And since the witnesses have claimed that the occurrence has taken place within 12 to 1:10 p.m. in the noon, common certificate and it is expected to have mentioned about the time of the father of the accused before the court on time and the evidence admits that the certificate is not in conformity with the time of the So the witness saying that the occurrence took place in the court hall of the author saying that in the court hall of the chief not received and the material discrepancies. The place of occurrence is doubtful. What?
No, no,
Your lordship, just a minute. Your lordship may turn to the evidence of PW4, who is none else the victim in this case and informant. Where the occurrence took place according to him, para 2 sir. The occurrence took place on 10/4/97 at about 1:30 p.m. at JMFC Rural Courtroom.
PW?
PW4, my lord.
PW4. Yes.
Now your lordship may turn to para 8 of this said witness evidence, cross-examination.
PW? Or
4, my lord.
4. Okay.
Para 2, I placed the place of occurrence, time of occurrence. Now it was explained in para 6. At the time of occurrence, the magistrate was present at the spot. Other staff members of the court are also.
Which para you are reading?
Para 6, my lord.
6. Okay.
Cross-examination.
At the time of occurrence.
Yeah.
The magistrate was present at this spot.
Other staff members of the court were also present. Now, this witness contradicts the other witnesses. They said, one witness said in the veranda of SDGM, other 2 witnesses in the veranda of JMFC, and this witness said, victim said that inside the court hall, the occurrence took place in presence of the magistrate and staffs of the court. So, whether if the court disbelieved 2 other offences on the ground of discrepancy, how the court believes so this aspect of the matter?
Okay, judgment. Mr. Raghuda, if you want to say anything, you tell me. Judgment reason.
Item number 82, your lordship.
Yes.
Well, item number
The
85.
82, your lordship previously called for the LCR. But in this regard, a letter is dispatched from the learned SDGM Dhenkanal, that is at flag A, your lordship.
Yes.
I think they not sent any LCR in this matter. LCR is required in this case, your lordship. Item number 82. Flag A.
LCR, what happened? According to notice issued on the concerned dealing clerk and who has been made response and he sought for 10 days time to setting. He needs 10 days time to ascertain the
Your
record.
lordship adjourn this matter.
Will be
after
adjourned,
15 days.
82 adjourned.
My lord, item number,
First week.
Item
my lord,
77, my lord.
item number 85, kindly to accept.
85. Why? Not 2 week, it will remain in the board.
Item
Revision
77.
don't mention, revision will be remaining in board. We'll
Item
see.
77, my lord.
Senior is not available.
77, my lord.
When it is called, then just say. Yes.
Item
Out of
77, my lord.
station.
Yes.
2 weeks after, my lord, the file has been misplaced.
Let it be there in the board.
What level to
Let it be there in the board,
Okay.
then it will be called, then you just tell. 77 adjourned. First week call. Get ready. Why can't you get ready? Revisions are pending since last 2 decades, 3 decades. Senior councils are getting ready. You can't get ready. You ready and come. If there is a chance of acquittal, we will acquit. Or already undergone, reduce the sentence or something. Okay. How many? Password matter will take it. 2. Revision also will take it. Right.
Though I have given the neighbors, there are 2 ways to distinguish. One is mentioned from the one or spell knowledge. I prefer this.
See, the allegations are, you are making serious allegation against the registry, what to do? You give him writing and take it.
This mentioning it.
Take the memo, just see. It is registered.
Again, number আমি mention করব
No, I think once it is registered, seriously, these matters are
part
listed.
of 559.
Why this is not listed, Jyoti? Huh?
This one should be listed actually.
Why if the matters are listed seriously, why one matter is picked up, the other matter is not listed, why this is happening?
Last 3 days.
Send the temperature to me. That is,
This one should be-
the allegations are serious allegations. Tell him to meet me.
I am a
I'll just see, if he is violated, then obviously he has to be taken into task. We can't leave it like that.
I am a pardon, your lordship. Item 74, your lordship. I could not reach your lordship at the time of call, your lordship. So, let matter already urgent to some other day. So, interim order to be continued.
Entry order will continue. If there is an entry order, that will continue.
Yes.
Need not worry.
And my appearance will be recorded.
74?
4 years. 74.
No, yes, no. Okay.
Highly obliged. Highly obliged.
Yes.
21. 21, lordship, that's there for time taking, that's there. And lordship, see, the informant's wife.
You could read
not
it?
less than.
You could read it? Just try to read it and I'll just hear it. I don't think anybody can read it. Just
Difficult to read, me. One says, that's it.
My lord, may I pass a judgment, copy of judgment, and your lordship may kind of have a glance of para 38.
because yes, there are some judgment which is at 306. You could.
But yes,
Interim compromise matter that cannot be passed. That is
That is the reason I am asking.
Yes.
Otherwise,
I will give some citation, lordship.
that's what I told you.
Para 30.
Because of considering the age and after the death of the informant, your lordship, not less than 70, but as for the record is 70.
1 minute. She is one of the huh?
Wife. My lord.
No, she is Tuni Samandra.
Puni Samandra. Lordship, see.
He is the informant.
Yes. No, informant's wife. Informant already expired, my lord.
Informant's wife.
Made a compromise in 2016. That is at Annex 2.
Her daughter.
Yeah, doctor, both lordship and original that death certificate and the legal error.
That's right. That's issued that.
And Shailawala.
Shailawala is the Bohutar, Putra Bohu. And my lord, one
Samantrai.
Lalat is there, not Peter. UD codes was registered after 15 days, FIR was lost.
And in this case also the same thing, 306, 498 and all.
That
The court said.
498 is different, but
No, here in
yes.
this case.
That case is, I have not gone.
The court should not, should
But he
take the all circumstances.
in peculiar circumstances, 2004, FIR has been registered.
And that is the reason I want to see what are the charges against.
Charges you lordship,
Charges at least is
11 line. And written, I can give
what
it
I'll
back.
do is,
Yes, sir.
I'll record their presence,
Yes, ma'am.
distance their presence for next date only.
Yes,
You assist me, how can we proceed?
Yes, Hon'Ble.
Huh?
Yes.
So that why
Yes,
you trouble these people?
Yes.
Yes.
On legal issue, we will.
Yes,
yes, ma'am.
And we will record his appearance and
Yes,
just
yes,
dispense with
yes.
their. Item. The petitioners have challenged the petitioners have filed the present petition seeking quashing of FIR number 29 PS case, one of PS case, PS which is the
Tangi PS case.
Tangi PS case number. Tangi PS case number
29.
2000.
Dated 21/1/2004.
Pending trial
Before the
in the court of Assistant Sessions Judge, Women's
Women's
Court,
Court,
Khurda, in
Yes.
ST case number 90/173/0807. 0807. Full sir. It is stated in the bar that the petitioners have settled their dispute. And have you filed the affidavit? Settled their dispute. The opposite part, the informant has already expired. The LRs of informants have already been included as opposite party number 2 and 3. The opposite party number 2 is a 70-year-old woman, and whereas the accused persons are also accused number 1 is also an elderly person. The FIR was lost in 2004. What are the circumstances you are telling?
against 5 persons.
Against 5 persons.
But charge sheet submitted against 4.
However, the charge sheet was submitted against the present 3 accused persons.
4 persons, then one has died in India.
Against 4 persons,
Oh.
and out of them, one of the accused persons has already expired. And in the FIR, the allegation against the petitioner is that, what is the allegation?
Allegation ଆମେ ତାକୁ କହିଲୁ ଯେ ଯୋଉଠି ଚାକିରି କରୁଛୁ
ଗୋଟେ ଲାଇନ୍ ପଢୁଥିଲେ ଆପଣ?
ହଁ ପଢିଯିବା ତା ଭଳିଆ ଝିଅ ବିଷ ଖାଇ
କିରୋସିନ ପକେଇକି ଜଳିଗଲା।
ଆସାମୀ ଏଇଠି ଶିକ୍ଷିତ ଭୁବନେଶ୍ୱର ଝିଅକୁ ହଁ କାଶୀପୁରରେ ଥିବା ପ୍ରାଇଭେଟ ଛୁଆମାନଙ୍କୁ ପଢେଇବା ସମୟରେ ଉକ୍ତ ସ୍କୁଲର ସେକ୍ରେଟାରୀ ପ୍ରକାଶ କୁମାର ସେଠୀ ମୋ ଝିଅକୁ ନିଜେ କହିଥିଲେ ମୋ ଝିଅ ଉକ୍ତ ସ୍କୁଲରେ ଚାକିରି କରିବା ଦିନଠାରୁ ଆମ ଗ୍ରାମର ଜଣେ ଆମର ଦିସ୍ ପିଟିସନର ତାକୁ ମିଶି ଝିଅକୁ ଅଶ୍ଳୀଳ ଇଙ୍ଗିତ କରିବା ସହିତ ମାନ ସମ୍ମାନ ହାନି
I'll take it up after. 65.
This is a matter, Madam, where your lordship had referred it to mediation. There also, and despite our best efforts, Madam, if your lordship may kindly see the mediation report.
1 minute. 65. Yes. Yes. Where is the mediation report?
Yes. dated
Okay.
19th of March 2024, my lord.
Yes.
Got it?
On consent, of the whole body.
On consent, so and so. The mediation sitting has enjoyed, in spite of the last but one paragraph, in spite of several persuasions, the opposite party number 2, informant does not want to settle compromise the matter, though the petition wants for settlement compromise. In view of the other, mediation becomes unsuccessful, office is requested to intimate.
Where is the opposite party number? Yes.
Now with this,
There is no chance then.
No, ma'am.
Yes.
Now may I consider your lordship with the merits of the case, madam? There's a 2-page short date, madam. That's for your lordship's convenience.
Yes. Yes.
Now here, matters. I am the petitioner is an elected secretary, matters. Now the date of occurrence is 1st of November 2022. The time is, it's very crucial, matters, 11:30 a.m. Now, matters, where a large group of persons, along with some security guards deputed by the developer, were removing certain material forcibly which belong to the Resident Welfare Association. Now, FIR number 306, lodged at 22.04 hours by Ganesh Malik, that is the informant matter, against, now Malan, kindly note this, Malaya Panigrahi and Sanjaya Patra and others under sections so and so, so and so, so and so. Now, the petition before my lords was not named in the FIR. Now, the petitioner's name, my lords, figured in the statement, my lords, made under 161, that also I'll show to your lordship. And subsequently, my lords, if they were implicated, he was implicated in the forwarding report on the basis of 161 statement. Now, if my lords may kindly turn to and then there was a cross FIR, my lords, 307, filed by the Residents Welfare Association against these persons, where the builder is also one of the accused, my lords. Now, if your lordship may kindly, and that is the problem, my lord, that cross FIR is the problem of implicating me falsely, because I was the one who was being secretary looking after the welfare of the association. Now, if your lordship may kindly see the first FIR, my lord, first, just to, if your lordship may kindly come to page 16, it starts at page 16, my lords. The relevant portion is at page 17, my lord. I just want to show to your lordship, I am not named here. No role is attributed to me because I was not there. So to that extent only. And then if your lordship wants to see that, otherwise, and then my lord may kindly come to the forwarding report.
Yes.
Counter FIR is the page 21-20. Forwarding report may kindly come to page 25. This is crucial, my lord.
Right.
Now, if you will kindly come to page 25. Now, forwarding the accused person, namely, my lord, so this is all the accused persons who were there at 11:30 in the morning when the incident actually occurred. So, in this, I am not here. So, your lordship may kindly turn over the page. And then it talks about all the sections which were registered in FIR number 306.
Okay.
Now my lord may come to page 27. Now, page 27.
Right.
Last 5 lines at about 5 p.m. My lord got it?
Yes.
At about 5 p.m., Biddu Bhushan Nayak of Z1 resident arrived there. He also abused in vulgar languages to Tapan Mohanty. Now, my lord may kindly make note of this. He also abused in vulgar languages to Tapan Mohanty. Tapan Mohanty is the builder.
1 minute. You are reading 27.
I'm sorry, my lord. I'm sorry.
Page
Page 27. Last 5 lines of the paragraph which is quoted there, my lords. At about 5 p.m. At about 5, last 5 lines, my lords.
At about 5.
At about 5 p.m. Now this is very crucial. May kindly make note of it, my lords. At about 5 p.m., Biddu Bhushan Nayak of Z1 resident arrived there. He also abused in vulgar languages to Tapan Mohanty. Now, my lord, please take note of it. He also abused in vulgar languages to Tapan Mohanty. Why this is very crucial, my lord? This
You are Biddu Bhushan.
I am Biddu Bhushan Nayak. I am Biddu Bhushan Nayak. Now, he also abused in vulgar languages to Tapan Mohanty. Now, why I am emphasizing on this is that this is what the forwarding report says. I just showed your lordship after seeing this. There is a statement. What does the statement of witness 161 statement says?
And threatened
And threatened the complainant and others On their way to police station to report the matter, they were also threatened for consequence, hence they complained being frightened and humiliated, lodged FIR in first the period. Then my lord, may kindly turn over page 28.
Yes.
The accused person so and so is involved in following criminal cases. One is of defamation, the other is PS case number 308. This is 306, 307. Then to implicate me 308 under section 353 that he tried to obstruct a public service. So this is the cases which is referred to. And then my lord, these sections and then my lord,
This forwarding report is in 307.
this 306. 307 is cross FIR. Cross FIR. Now.
And what is 308 then?
So 308 is that I am the secretary, so I am the main problem over there.
Right.
So according to them, I not only threatened them in the evening. I was not there also. I didn't know. I not only threatened them, my lord. I also went and fought with the police officer. So 353. So without me getting in, how will the
In this case, you are challenging 306.
I am only challenging 306. I am not in 308.
Yes.
Then my lord, and may kindly see my lord. I was then the offenses charged are 341. May kindly note, my lord. 341. So gradients are not made out at all. So now, my lord, with this, and now my trouble, your lord. Steps 2. Now, with the back to my lord, that out of these three sections, 341, 294, and 506. Now, I was arrested on 1/11/22 at 11:30 p.m. and I was in custody for 14 days. I got bail on 15. Whereas, my lord, 341, 295 are both non-cognizable. Now, then your lordship, I was granted bail on 14th November, and then charge sheet was filed on 26/5/2023. And cognizance was taken 5/6/2023. Here I am challenging the cognizance order as well as the criminal proceeding. Now, my lord, my trouble your lordship to the additional affidavit filed by us, my lord, the thin paper book, my lord. Additional affidavit.
Yes.
Now, your lordship, may kindly come to page 9, my lord.
Page 9.
Please, my lord. Now, this is the copy of the FIR by Ganesh Vade. Now, lordship, may kindly turn over page 10. Now the statement starts. And if your lordship may kindly turn the third page of my note, my lord, the third page.
Yes, sir, that is it.
I have
1/11.
I have given the details of all.
1/11.
Now your lordship may kindly see page 10, last 4 lines.
Yes.
Thereafter, now, prior to that, my lord, not a word about me. If your lordship wants me to read, I'll read the entire statement. Otherwise, relevant portion is
page 9, nothing is there.
now page 9, nothing is there. Page 10, first 15 lines.
Page 9 is whose statement is this?
The Ganesh Vade, the complainant, the security guard.
He doesn't say anything.
He doesn't say anything. Then may kindly come to page 10.
Okay.
Now, page 10, first 17 lines. If your lordship may kindly, if your lordship wants, I can read that. Nothing to do with me.
No, read relevant time.
Relevant is last 4 lines.
Yes.
Thereafter, our staff took us. Now, they are injured persons over there. So now what he is saying is, the security guard is saying, the complainant is saying, yeah, after all these injuries were caused and by these people where I am not named also. Yes. Thereafter, our staff took us to the hospital for treatment. Now, full stop. Now, my lords. Later in the evening, Bidhu Bhushan Nayak, that is the petition before my lords, of Z1 phase 1 arrived and said, let us see how that now. What do I say, my lords? Let us see how that Tapan Mohanty would work here. Now, Tapan Mohanty is not even assuming, although this is all my lords concocted, I was not even there at that time also, but assuming against me as it is. Now, what he says.
What you are trying to say is Tapan Mohanty is the stranger to the entire story.
Tapan Mohanty was not there also. Yes. And in the forwarding report, which I said, he said, I gave filthy abuses to Tapan Mohanty.
Right.
Now, and that how that, and there's in Uriya, my learned friend had told me, I don't know Uriya, that Sala word is the only word that was used. He was Sala Tapan Mohanty. Right. So let us see how that Tapan Mohanty would work here. and issued a life-threatening warning to anyone approaching this location, because of which we are in state of fear. While we were on our way to report the matter to the police station, Biddu Udesh Vinayak threatened us on the road in front of the police station. Even before this, they have fought with us and threatened us while working. This is my true statement. Now, my lord, take note of this. Now, I am kindly turn over, my lord. I'm sorry, my lord, I'm troubling your lordship because it is parrot like ad verbatim. Every word is the same.
Right. And
Then my kindly turn page 12, my lord.
the same thing.
Everything, my lord. Then page 14, my lord. The third one. That is why in that one page chart I have given, my lord.
Right.
So, my lord, with this in mind, my lord, now your lordship may kindly see that
Yes.
now, my lords. So, my lord, first FIR 306 lodged against several residents who were present. Occurrence is of 11:30 a.m. They are I am not even named in that. Second cross case comes just 20 minutes after that against the builder.
Who is the complainant in the cross case?
Udai Tripathi, one of the residents. Against the builder and the other persons who were trying to forcibly take away the material of the resident welfare association. Then my lords. So after this, my lords, but the main person, the petitioner before my lord, the secretary, he is the person who is causing all hindrances to the work being done. So, my lord, 161 statement comes into picture, and after 161 statement comes into picture, I have read those statements, my lord. Then I am implicated. I am not only implicated, I am also arrested, my lord. I am arrested, and if your lordship may kindly see the bail order, that is very crucial. I'll just show your lordship the bail order.
Yes.
May kindly come to my lord's page 37.
37. Yes.
37.
Yes.
Now, 37, I'll just show your lordship that all the accused had applied for bail. All the accused except me were named in the first in the FIR for the first incident.
Right.
So now, but I am also clubbed with them. So may kindly come to page 38. I'll just show the relevant portion. I'll not trouble the lordship. Page 38, first paragraph, last 7 lines. Learned advocate for the accused. I have got it.
Bidhu Nayak.
So Nayak submitted that the said accused was not present at the time of occurrence, and in the evening he came to the spot and threatened Sapan Mohanty by taking his name. He further submitted that police has forwarded in under section so and so, and his earlier application was rejected on technical grounds that the victim was not heard at the time of hearing of bail application, hence prayed to release the said accused on bail. The matter may turn over. Now may kindly see page 39. The case of the prosecution. The case of the prosecution in brief is that on 1/11/2022 at about 11:30 a.m., informant Ganesh Malik had gone to Z1 phase 2 for work.
I understood it.
Why? What is important, my lord?
What you are trying to say is the incident has taken place at 11:30 a.m.
Please, my lord.
FIR was registered at 22:04. And the incident, you have participated, if at all, in 161 statement, your name.
I was implicated.
Implicated at evening, something has happened.
At evening, nothing has happened. So
you have threatened to someone else who is nothing to do with this.
First, there are two parts. Very interestingly, there are two parts. First part says, I come back to my society. I'm just assuming, my lord. The security guard says कि साहब आज तो बहुत गड़बड़ हो गई, and all these things have happened today. So then वो साला तपन मोहंती बदमाशी करता रहता है, उसको या इसके अंदर घुसने नहीं दूंगा. So that is
there can't be any offense to that.
There cannot be any. For 506, I have got judgments also, my lord. 506 requires, the latest judgment of Supreme Court says the threat should be such that it creates a fear of the person to whom it is given. Then what they feel is ये तो अभी बच जाएगा. Then they say that while they were going, because the FIR is lodged at 10 p.m. at night, the first FIR and cross FIR also. So they say that जब वो जा रहे थे वहां, when we were going, then he again threatened us.
Yes.
Then your lordship, why I was reading this para is important. It says that subsequent, last 4 lines of this say, it is further their case that subsequent to the incident, accused Nayak had come to the store in the evening, threatened and abused by uttering the name of Tapan Mohanty. So that is, I am threatening and abusing. Please note, Tapan Mohanty. Tapan Mohanty is not their case, is ever present there, either at the police station or at the society where the occurrence has taken place. This is a very, very crucial factor. That's why I was reading. Then you are
Tapan Mohanty is cited as witness?
Tapan Mohanty, no, he is an accused in 307. No, in this charge sheet, no, he is not. He is not.
He's not charged.
No, my lord. He is a player. He is a big player. Now, your Lordship, may kindly turn over, my lord. Please, you get your chance. You can say whatever you want to say. That is my.
Yes.
I'm only addressing the court. Please don't disturb. Now, my lord, may kindly see page 40. 40 last paragraph. This is the successive bail application of accused Bindu Bhushan Nayak, and his earlier bail application was disposed of on 4/11/2022 without hearing the victims on being moved by learned advocate for the executive. It is apparent from the record that the said accused was not present at the spot at the time of occurrence, and he has been forwarded under section 341 294 5006 of IPC. It is further surfaced from the record that said accused is involved in 2 other criminal cases, one which I said under so and so, and the other is 308 under 353 332. The accused is inside custody since 2011, therefore taking into account the nature of accusation made against further detention so and so. We got it. Now, your lordship, may kindly see the section, my lords, which are
What are the judgment you want?
judgment I just see, my lord. Just the sections I just wanted to.
Yes.
It will not take much time, so a very small section. First one is 294, if your lordship can see, 294. Obscene acts and songs.
Yes.
Obscene acts and songs. Whoever, to the annoyance of others, A, does any obscene act in any public place, or B, sings, recites, or utters any obscene song, ballad or word in or near any public place shall be punished with. So I have read the entire thing, my lord. To the best of my understanding, I don't find any of the ingredients. Now, your lordship kindly come to 341. 341.
Yes.
Punishment for wrongful restraint. Whoever wrongfully restrains any person shall be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 500 rupees, or with both. So, in the statement which I read before, my lords, as well as the forwarding report, it doesn't say that I have restrained anyone, my lord. So 341, now my 506, my lordships are very well aware of 506. Whoever commits offence of criminal injury shall be punished. So definition is 504. Now, my lord, may kindly see the case laws, if I may. I have just a written submission, 3 pages that will.
Now, facts are very clear.
Facts are very clear, man. Now, your lordship,
I'll just look into all these.
The only thing is, madam, right from Bhajan Lal to latest Justice Pardiwala. Madam, Justice Pardiwala goes to the extent of saying, my lord, that even in cases, my lord, where the High Court prima facie feels that 482 should not be exercised, my lord. Justice Pardiwala says in judgment that the High Court owes a duty to see that if any report is not lodged out of vengeance. If you want, your lordship, I can read that, madam. I have the.
Which judgment? That is 2023. 616.
Please, madam.
Give the judgment. And
I'll give all the judgment.
Highlight that portion, please.
Okay, I'll highlight.
Please highlight. You tell your instructing counsel to highlight so that I can read it. Highlight and give. Yes, Mr. Bar.
Let him state counsel plus first, then I will.
Yes.
Yes.
So
I'm so grateful, ma'am, for patience.
So far as the first 11:30 incident is concerned, he doesn't have the road. He comes in the evening, and he only what is his submission? He only says that let us see how this builder will work. I will not allow him. This is what is the long and short of the allegation is. And charge sheet is also says that 161 statement is also saying that in that if those facts are taken into consideration and taken into face value, how will you make out a case under 294, 341 and 506? That one, that is the issue. You tell me.
But the statement, my lord,
Hmm.
I have obtained the case, my lord. Ganesh Malik, my lord, the complaint. He says, relevant person. 1/11/2022 ଦିନ ସକାଳ 11:30 ସମୟରେ ମୁଁ ଶିବବ୍ରତ ହୋତା, କାଳିନ୍ଦୀ ପଦ, ସନ୍ତୋଷ ପଲେଇ, ଜୟନ୍ତ ପ୍ରଧାନ, ରାମଚନ୍ଦ୍ର ଧୋବେଇ ନାୟକ ଆମର ମାଲିକ
11:30, that is the story of 11:30. What is his role? What is
ଏଠି ଆମେ ଡ୍ୟୁଟି କରୁଛୁ ବୋଲି Z1 ରେସିଡେନ୍ସ ଆସୋସିଏସନର ସେକ୍ରେଟାରୀ ମଳୟ ପାଣିଗ୍ରାହୀ, ସଞ୍ଜୟ ପାତ୍ର, ଅଲେଖ ପରିଡ଼ା, ସିକ୍ୟୁରିଟି ଗାର୍ଡ ସୁଜିତ କୁମାର ଦେହୁରୀ, ଶିଶିର ଶତପଥୀ, ତାପସ କୁମାର ନାୟକ, ତୋଫାନ ସେଠୀ, ତପନ କାଣ୍ଡି, ସୁବ୍ରତ କୁମାର ନାୟକ, ଆଲୋକ କୁମାର ଆମକୁ ଜୀବନରେ ମାରିଦେବା ଧମକ ଦେଇ ଏବଂ ସଡ଼ା ଛୋଟ ଜାତି କଣ୍ଡରା ତୋର 5 ଟଙ୍କାର ମୁଣ୍ଡ
all
ପାଇଁ
these things are at 11:30. Forget about it.
କଲେ ମତେ ବଞ୍ଚେଇବ ରାମଚନ୍ଦ୍ର ପହଞ୍ଚିଲେ ତାଙ୍କୁ ଦେଖି ମଳୟ ପାଣି କହିଲେ ଅପସିନ୍ ଲାଙ୍ଗୁଏଜ ମା ଶେଷ କରିଦେଲେ ଜଣେ ମରିଗଲେ ସମସ୍ତେ ଚୁପ୍ ହୋଇଯିବେ ଆଉ ଜାଗାକୁ Z1 ମାଲିକର ଲୋକ ଆସିବେନି ଏତିକି କହି ରାମଚନ୍ଦ୍ର ପାତ୍ରକୁ ମଧ୍ୟ ଜୀବନକୁ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ରଖି ଲୁହା ରଡ କାଠ ଫାଳେ ତା ମୁଣ୍ଡକୁ ମାରିଗଲେ ମୁଣ୍ଡ ଫାଟି ଯାଇଥିଲା ଅଚେତ ହୋଇ ତଳେ ପଡିଗଲେ ଏହି ସମସ୍ତ ଉପସ୍ଥିତ ଉପରୋକ୍ତ ଲୋକମାନେ ଆଣିଥିବା ଟ୍ରାକ୍ଟରକୁ ମାରଣାସ୍ତ୍ର ସାହାଯ୍ୟରେ ମାରି ଭଙ୍ଗାରୁଜା କଲେ ଧୋବେଇ ନାୟକକୁ ମଧ୍ୟ ମାଡ଼ ମାରି ମୁଣ୍ଡ ଫଟାଇ ଅଚେତ କରିଦେଲେ ଆମ ଜାତିକୁ ନେଇ ଗାଳିଗୁଜ କରିବାକୁ ଆମେମାନେ ବହୁତ ଲଜ୍ଜିତ ଅପମାନିତ ହେଲୁ ଏହାପରେ ଆମ ଷ୍ଟାଫ ମାନଙ୍କ ଆମକୁ ଚିକିତ୍ସା ପାଇଁ ଡାକ୍ତରଖାନା ନେଇଗଲେ ଏହାର କିଛି ସମୟ ପରେ Z1 phase 1 ରେସିଡେନ୍ସ ଆସୋସିଏସନର ବିଧୁଭୂଷଣ ନାୟକ ମାନେ ଟାଇମ୍ ନଟ୍ ମେନସନ୍ ଏହାର କିଛି ସମୟ ପରେ ସନ୍ଧ୍ୟାରେ Z1 phase 1 ରେସିଡେନ୍ସ ସନ୍ଧ୍ୟାରେ Z1 phase 1 ର ରେସିଡେନ୍ଟ ଆସୋସିଏସନର ବିଧୁଭୂଷଣ ନାୟକ ଆସି ପହଞ୍ଚିଲେ ଓ ଶଳା ତପନ ମହାନ୍ତି ଏଠି କେମିତି କାମ করে ଦେଖିବା ଯିଏ ବି ଆସିବ ତାକୁ ଜୀବନରେ ମାରିଦେବା ବୋଲି ଧମକ ଦେଲେ ଯାହା ଫଳରେ ଆମେ ସମସ୍ତେ ଭୟଭୀତ ଅବସ୍ଥାରେ ଅଛୁ ଆମେମାନେ ଏ ବିଷୟରେ ଥାନାକୁ ଜଣାଇବା ଯାଉଥିବା ସମୟରେ ଏଗେନ୍ ବିଧୁଭୂଷଣ ନାୟକ ଥାନା ସମ୍ମୁଖ ରାସ୍ତା ଉପରେ ଆମ ଲୋକଙ୍କୁ ଧମକାଇଲେ ଏହା ପୂର୍ବରୁ ମଧ୍ୟ କାମ କରୁଥିବା ସମୟରେ ଅନେକ
another FIR 308 is raised.
ମାନେ ଏଇଟା ହଉଛି ପୁଲିସରେ ଦେଇଛନ୍ତି पुलिस की 353 there, my lord. So, but this FIR 306 is concerned all the allegations against the petitioner. I have read out last portion, my lord, that is the against the petitioner, my lord. So far, my lord, here, my lord, the case, my lord. So far, 307, even if the injury is simple injury, my lord, cannot be injuries are criteria for the 307. Even if the no injury, my lord, can be but 307.
307 against him, there is no 307.
Against him, this is not the time, my lord, to
That's right.
segregate the what is the allegation against one and 34 is there, my lord. 34 is there, 36 is there, my lord. It is a preliminary stage, my lord. Cognizance taken, my lord. This is not we are doing the military trial, my lord. That the scrutinize the evidence 161, my lord. 161, my lord, means for the purpose of my lord contradiction and corroboration, my lord. That cannot be taken into consideration at this time, my lord.
Yes.
This is not the stage, my lord. The cognizance, but there are prime facie case made out against all the accused persons, including the present petitioner, my lord. The cognizance cannot be quashed at this stage, my lord. That is my submission.
Yes,
My lord, your lordship, kindly see page 68, my lord has taken your lordship to that portion.
68.
Page 68 of the brief.
Okay.
Odia, my lord.
Yes.
Last, my lord. My lord has taken your lordship to that portion.
Yes.
That I did not repeat it. Then, your lordship may kindly see page 94.
94, yes.
Ramchandra Patra. Same thing, my lord. Then 95.
Not the same thing.
Same thing, my lord. In total, 9 witnesses have given their statement implicating him. So,
In so far as the incident in the evening is concerned.
yes, my lord. While going to the hospital or before that, just before that, 2 parts, my
But
lord.
he has not participated in 11:30 incident.
No, that is not the case, my lord, at all. But now, my lord, so in these my circumstances, clearly 506 is made out, and so far 294 is concerned, my lord. There is no bar in the statute that only the person who is abused can lodge the affair. My lord, if the statute does not bar, anyone can set the criminal law into motion. So,
Their cognizance offenses.
yes, my lord. So my submission is, so far 341 is concerned, while they are going to the police station, they have been given that amount to restraining them, obstructing them. And furthermore, he is such a person, influencer person, he had threatened the police officer in the police station, for which the police officer has filed the FIR against him, that is 308.
So both of you are influenced. That's the
No, my lord, on that no, we are not implicated. Police officer has submitted the FIR, that is PSK 38.
But why the builder who's, in fact, he says that I will not allow this builder to come inside the society. And that builder is neither cited as witness nor anywhere is he there.
My lord,
And
builder was not present.
It is
That
complainant.
That incident, my lord, your lordship,
The informant appears to be playing under the hands of the builder. That appears.
no, my lord, my
Police-
submission is, the fact has not been stated properly before lordship. Fact remains, in the ground floor or in the basement, there was more than 5-6 lakhs of Italian marbles of the builder. The staffs, including the injured informant, they are trying to remove it. At that time, the incident took place. That you cannot remove this. A flat owner under no circumstances who has purchased the flat in finishing one and residing there cannot stake or store such huge quantity of marble in the basement or ground floor. And the cost of square foot marble is more than 350.
That is the reason I was relegating you for settlement. And
No,
you
my lord,
signed a-
my lord, he is the mastermind. He is everything is
How many
because of him.
How many cases are filed by him against you and the builder?
My
And
lord,
how many you have filed against them?
I have not, the bill, so far the builder is concerned, he has not filed an FIR.
How many cases they have filed against you?
My lord, according to them, only 307, PS case number 307 is filed against me, but I have not been noticed so far in that case. That is under investigation. And in the present case,
Apart from these 3 cases,
my lord,
306, 7 and 8.
8,
And what are the other cases pending?
against us there is no case. And rather, they have made so many defamatory statements, for which 2 defamation case in civil court is pending, and 1.
Why can't we quash everything and
My lord,
why can't you?
my submission is such a person, if it will compromise, will accede to his demand, my lord.
You will bound him.
He will not be bound, my lord. He is such a person. And because, my lord, he is escaped. And your lordship knows very well, my lord, from the experience from here and in Delhi, my lord, in charge sheet, my lord, 2 different stages of that one person is charged on this, one person is charged on this, never. It is not never. He may be. Now, question remains at present.
Charge said it will be segregated.
My lord, that will be in trial. And now question is, my lord, now at the stage of charge, framing of charge, and some of the accused persons who are not on these offences, they filed their discharge application that has been rejected. So, if there is no material against him and no offence is made out either 294, 341, 506, he can be discharged. Charge may not be framed against him. Or if material is there, charge implicating him.
Now, what is the material? I just want to know what are the materials, except these 2 sentences at the end of
Now,
at this stage, what is this?
At this stage, nothing is there. At this stage, nothing is there. It may come up in trial, my lord, in evidence.
319.
My lord?
If it comes up 319.
That is a different issue, my lord, but he is named.
So
Therefore,
therefore,
19 is also not named.
See, looking into all this thing only, I was under the impression that if it was sent to the mediation and things will be sorted out. And
My lord, because of his threat, my lord, I am a poor person. And I was working in Bhubaneswar. Now the builder make me out after this incident. With much request, I am working at Berhampur only, my lord. That is hand to mouth. Because of this.
Anyway. Okay, if you all of you want to file your
written submission, yes, we'll file
that and
only one reply, only one. If you lordship kindly come to page 66, 67, what my learned friend said and what my I just want to clarify. Page 67, if your lordship, this is a charge sheet. Now in charge sheet, my lord, to the little knowledge which I have of criminal law, my lords, I am only charged under section 341, 294 and 506. Where does 34 and 307 and other things will come?
Where is which part of
page 67? Page 67, my lord. page 67. Can we come to page 66? I'll just review 3 lines here and 3 lines there. Page 66, middle, at about 5 p.m. Got it? Nayak, so and so. Right there, he also abused vulgar language upon Monty and his worker while other workers were on the way. So and so. Then Lordship may kindly turn over that last line, my lord. Alok Prada, and under section 341, fifth line from the bottom.
Yes, yes.
And under 341, 294, 506 IPC against accused person, so and so. And then again reiterated at page 67, under section 3.
Charge sheet is filed or not?
Charge sheet has been filed, my lord. So this is the charge sheet which I am reading.
Cognizance is also.
Cognizance is also taken under this. So I only wanted to say. I am so grateful, my lord, for patient hearing.
Keep your.
So far, you are also asking my senior my lord, how many cases, my lord? So far, the Malaya.
They have decided to keep on fighting throughout their life. Let them do.
There are 6 cases, 5 cases against Malaya and another my lord. And 2 cases against the president.
I showed to
2 cases means
308.
308. 7 and 8.
And I have also given one judgment to my lord of Supreme Court.
What are you doing for living?
I am a chartered accountant, man.
You are not doing good in your profession.
I am doing quite good, my lord, in my profession. But I have
happy engaging yourself in society, politics, and all.
I have this thing of public service a lot. So this is what I'm doing as progress. I'm so grateful, my lord, for patient hearing. I have given my written submission also, my lord. And now the judgment I have given a high level. There's a judgment of Justice Pardiwala, my lord, latest, where he says that even he goes to the extent of saying that even there also, my lord, he was a history sheeter. But the FIR, which he was, the charge sheet which he had gone for quashing, I have given that judgment. So the Justice Pardiwala says that even if there are 20 cases, if in that particular charge sheet where he has been, there no prima facie, no cases made out, it is bound to be quashed. And he quashed it. I am so grateful, man.
Thank you.
Thank you.
Yes.
Like that.
50. 50. Yes, my lord. Yes, 50.
May I please, Your Lordship?
Yes.
But here, what the petitioner is suffering is that the duped, my lord, the builder has duped the petitioner as well as other investors. Now, the petitioner's property.
Mr. Mia was here.
Yes, Mr. Patra will be.
You are there?
What the builder has done to get bail from the lower court, he has given security, my property, as a security for the bail. So I applied for release of that. Now here your lordships may keep in mind, it has not been attached, but it was given as a security in the bail petition pursuant to the order passed by this honorable court in the bail application.
How are you related with the builder?
There is no relation at all. I had given the property for development in turn to get 30% of the building. My building would be developed and he will sell the other portion. That is by way of a notarized agreement. Yes. So thereafter.
And showing that agreement only, he sold the property.
Yes. He not sold the property. He has given that as a security, that property as a security for securing his bail. Peculiarly, that the OPID court didn't take that into cognizance. It accepted the security. Now, I moved an.
If you are the owner, how can he give security?
Exactly, my lord. That's the point. The court has accepted. Rightly or wrongly, it has accepted. So 443 is the provision under which I applied to the court for release of the property. But unfortunately, the court does not prescribe for release, but says that it is only that the person who has been released on bail in case of fraud can be brought to custody, but does not speak about release. That is why I am before your lordship for under section 482. Now,
Where is that? Where the security? Where is that order proceeding? Where the security is accepted?
Yes. That security order I have not placed, but the impugned order says so.
No, where is that? That order will decide. In what circumstance?
Annexure 7. Annexure 7, page 57 to 60. That's the affidavit.
Yes. Yes, that is the affidavit. I know that I have seen.
Yes.
That's the affidavit is there.
If the original owner doesn't come forward
Yes,
and standing as a surety
yes,
with the papers, original papers,
right,
how the original paper is bought by someone else
yes.
and how the original paper has gone to the accused hand.
It is not the original paper. It is only the agreement which has been brought given.
Agreement can't be taken as a surety.
But it has been accepted, and that is
Where
under
is that order? Show me. Accepting the agreement as a surety.
the
How
order with
an
the
agreement can be a surety?
no. What has happened? That order is not with me, my lord. The order which
If
is
you have in your people, just see. That order will decide
no.
in what
It has
circumstances he has accepted it.
it is
Whose firm is that?
it has been accepted is there in the order itself, which is before your lordship, which I am not impugning though, but it has under 443 it has been passed. That it is there under the seizure and that is at page 75, annexure 10.
Okay.
There are two orders. First,
Then you moved an application under section
443.
440.
That your lordship may see. Page 76.
I'm there. Yeah.
It says, on that score, the learned counsel for the OP filed objection that the same was earlier raised by the petitioner under section 439B2 of CRPC dated 22/12/2017, filed by the prosecution under section 443 CRPC, and the petition dated 14/5/2019, praying therein to release the property placed before the court while enlarging the accused on bail under section 443 of CRPC, and to cancel the bail bond punished by the said accused for violation of conditions of the bail under section 439B2 of the CRPC, and this court has dealt with the same only on 28/2/2020 with the finding that till disposal of the civil miscase pending with this court regarding attachment of the property for the civil miscase such and such, and this petition preferred by the present petitioner subsequent to the said order of the court on dated 28/2/2020 as such merits no consideration. So now your lordship if would see that order dated 28/2/2020.
Right.
That's more elaborate an order. 28.
Yes.
Yes. Hello, what I am praying now is this civil miscase that be targeted, and because it is under fag
How
end.
can in a 482 I can target that civil case?
Civil case is arising out of this OPID proceeding only.
I don't think.
It is there in the statute under section 9.
Stage of that civil case.
Only IO is to be examined, and he is not Tanima. That is the problem. If that
Here, but my concern, my lord, section 13 of the OPID is very clear, lord. Any person including the competent authority, if agreed by
any order,
an order of dated court may prefer an appeal to the High Court within 30 days. Then here, my lord, our High Court judgment, my lord, regarding the civil part, attachment, my lord, he has to file an FAO.
I know that.
no, I am just asking for completion of that proceeding.
File FAO, my lord.
In 482 I can't.
The problem here is that is for attachment, and it is not attached. Here the question is it has been given as a security for bail bond.
But there are, see, you have entered into an agreement. That agreement is part of that entire deal.
Yes.
And in what circumstances this was filed as a surety or not, I don't know. You don't have that order. You show me that order. Why the court has accepted that as a bond at the first instance?
That is pursuant to the bail order, which has been.
I don't know whether you appeared there in the court or not. You might have appeared. Today you turning around and saying that no. How do I know?
No, I have not appeared. I have.
But I have to see that order. If you have gone yourself, along with the original document. and agreement to sell, and you said that I stand as a surety, court might have accepted it.
My lord, for that purpose, I will place that order in the next
Very
date.
important.
Yes, I got your lordship's point. I'll
But
place that.
otherwise, why a special court, a sessions court, will
Yes.
accept a bond on the basis of security, on the basis of a agreement to sell, notarized agreement to sell that.
What had prompted is this order which has been
And
wrong.
who has that original paper of that document of the property?
Now it is under seizure by the OPID court from the petitioner.
How it has gone to that?
Because the property was involved in the dispute. That is why.
There are stories inside stories.
No, that is correct. That seizure is there. Otherwise, I could not have gone to the court. The
I
seizure
don't
of
know,
the.
you might have gone to the court to as a surety. I don't know.
I'll bring that. No, that is.
I'll put it first week, May. Mr. Rathar, Learned Counsel for the petitioner seeks time to submit further documents to substantiate the case and release the matter. And Mr. Das submits that he would also seek instruction regarding the status of miss case, civil miss case number 3 of 2017.
My lord.
Pending in which court?
OPID Balesur.
Pending before OPID Balesur. Yes.
District Judge come designated court OPID at Balesur.
Please the matter. One matter is there? Yes, only one matter. Yes. Yes, ma'am. We will have a camera proceeding or camera proceeding?
Declare court way.
Lordship have options. Either the court to be declared as a chamber or lordship.
What? Nobody is there, everybody will go now.
Yeah.
Nobody is interested to be there.
That is here lordship.
Or we can-
It will be more cardinal if it is taken in the chamber.
And I will be happy, all of you will come to my chamber.
Yeah.
We'll have a cup of tea.
Yeah, so, that's-
Please.
Fine, then it's-
Right.